I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, friends. I just got home. I am not ready at all, so let me get everything pulled up. It took me a little bit longer at the doctor than I thought. I was, and I almost scheduled this for 2 o'clock just in case, 2 o'clock my time, just in case. And I was like, no, I'll be done. It'll be fine. But that's okay. All right. Ashley Benefield. Law and Crime. They usually have the best audio. We'll start there. All right. Let's get this show on the road. It's thundering outside. Hello, welcome. Hello, hi. Sorry I'm a few minutes late. I was trying to hurry when I left, but I am here now and we are ready. I have not watched anything today. I have seen a few messages from people saying that they did jury instructions and then they're doing closing arguments. I am really excited that we get to do closing arguments and jury instructions at a little bit of a faster speed because Law knows they talk so slow. So I am really, really excited to be able to do this at a faster speed. That is exciting for me. All right, let me see. Let's share this. Share screen, entire screen, share. There we go. Look at us go. All right. Hello, friends. Are we ready? Let's see what we can accomplish. Let's actually, you know what? For jury instructions, because I think that's the first part from what I understand, they do jury instructions first. Let's do it a little. Oh, wait. They had 3 rebuttal witnesses first. That's right. I forgot about that. They had 3 rebuttal witnesses first. Look at me just trying to speed through our day. So we'll stick at 1.25. I forget these things. Get the jury in here. All right, so Eva is back on the stand.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
And when was that picture taken?
That was taken in 2018.
And then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
Oh. And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Okay. Judge, I just want to publish it briefly. Oh, at this time, I'm going to enter State's Exhibit 105 into evidence.
Same objections? No objection. No objection. Proceed.
There. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
Oh, so they.
Can the witness be released from her subpoena?
Yes.
Can the witness be released?
Cropped her out.
Can the witness be released from her subpoena? May be released from your subpoena. You're free to go.
Thank you.
Thank you. State.
State has no further witnesses. Thank you.
All right.
Oh, that was
All
it. I thought I heard somewhere that
At
they
this
did 3.
point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about 3 things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, did anybody want to be heard before?
Okay, so this we can zoom.
And get you back up here and get going with, if you remember, it's going to be some initial instructions by me on the law. Thank you. I do. I had to print out a copy for me.
Hello. Hi.
All right, so
Some of you may have already seen this. I know
I
that.
assume that this has all of the changes that we discussed yesterday?
Yes. To the best of our ability, yes.
All right. So let's go ahead and take a run through these. And Ms. Benefield, please feel free to share a copy with your attorney, look over his shoulder. So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections.
Okay, do y'all want to listen to them argue over this, or do you just want to skip to where he's actually reading them, the final stuff? Because I don't know if we need to hear them argue over it necessarily, or like do the debate stuff, or if you just want to get to the part where they're reading it, where he reads it to the jury, so then we can. Everybody says skip. I figured that was okay. I figured, because this is kind of. So this is still them discussing, and then they take their break. It is thundering. I feel bad for her. Oh, you want to listen to closings now, and then listen to the instructions when they go into. We can do that. We can skip straight to the closings and then go back and listen to the instructions after the closings, if you want to do that.
Felony of aggravated assault are 3 dots. If you look at the instruction, the way it doesn't say.
Oops.
So what I am proposing, they approach.
All right.
I've shown this to Rebecca. Perhaps if we could just number them to give them.
Lights down.
Yes, if we could just see the ones back there.
Okay, so this is.
State.
Can I have the screen, please?
Yes. And how much did you want to reserve?
That's what I love about speed trial, and we get to do it how we want. We can listen to the closings and then go back and listen to.
Yes, if we could just see the ones back there.
The instructions and talk about how the instructions are to see.
Domestic violence is absolutely a real problem. There are many, many women around that are in horrendous situations. Women, and sometimes men, that are in situations where they're being abused and beaten horribly on a regular basis. People that feel like they cannot get out, they have no way to get out. That is not this defendant, and it never was. Now, some of those women who are victims of horrible domestic violence may be justified in a situation where they have to use self-defense to kill their abuser. Absolutely, there can be situations where that might be a valid point, but not for this defendant. This defendant used domestic violence and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs. And to understand that, I think we need to go through the background, even though this case really is about what happened in that house. What happened in that house, the last moments of Doug Benefield's life. But we need to go through the timeline to see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary? That self-defense instruction, it's called justifiable use of deadly force, is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name calling. Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided, in less than a year of marriage, they wanted to have a child. This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it. If you look at the emails, the text messages between him and Ashley, he says, "I'll spend the rest of my life making this up." And he says how wrong he was and how stressed out he was. And he apologizes. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy. And then within about 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last moment that this defendant ever lived in the same house with Doug Benefield. Was August of 2017. Very, very important date. Within a couple of months after getting to Florida, the defendant starts this campaign of complaints against Doug Benefield, all with the idea to get sole custody of her child that she was pregnant with. So she filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against, but finds it appropriate to get an injunction in South Carolina. It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. That is not what we are used to probably in Florida for injunctions. Then December 2017, so that's within a month, Ashley starts the series of allegations in Florida. So she files for this injunction in South Carolina. They mutually agree, okay, we're not going to talk to each other, we're not going to be around each other. But she starts a series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child, and also goes back to things that he supposedly did in South Carolina when they don't even live together. So on March of 2018, she gives birth. She gives birth after Doug Benefield has a lawyer contact her, because they're not really supposed to be talking to each other. The lawyer helps him write a letter where he says, I want to be a part of this child's birth. Please, I'll honor your wishes, but please let me be a part of this child's birth. Not only does she not respond, when she goes early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, he didn't know the child was born. Then she does not put his name on the birth certificate. Now, alleged behavior or not, she knows who the father is. Why is she not putting the father on the birth certificate? And then she gives this child her maiden name instead of her father's maiden name. Or, I'm sorry, her father's last name. Then 1 month later, she starts complaints to law enforcement. She says he violated the injunction in South Carolina. She files for a new injunction in Florida based on all the same things in South Carolina. This is all based on the same information that she had already spoken about in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. And you heard from Detective Gillum about the conversations that they had. And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive, it is her plan, it is what she did everything for. He said her true motives were to use the criminal system to affect her family court case, to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, "If the judge sees him arrested, it will help me keep my baby." She wanted him arrested in family court in front of the judge and made that very, very clear. That was what was important to her. The detective said in 20 whatever years that he's been doing this job, he has never had anybody ask him to do that. Never. And she was very adamant. And they talked for 15 to 20 minutes. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs, all because she could not get him to go with her plan. She also said to him, "You will fucking arrest him in front of the judge, and I will make sure that you do." Then she said, "I will do anything I have to do to keep my baby, asshole." She wasn't saying, "I'm so afraid of this man. Please help me. I'm a victim of domestic violence. I need help." Not at all. She's saying, "I want to keep my baby." And she's afraid that this man, who is 30 years older than she is, and a lot more established, has a lot more money, has a lot more resources, she's afraid that this man is going to get custody of her child instead of her. So after this discussion with Detective Gillum, in about September 17th of 2018, the second hearing for the injunction happens. Remember, this injunction hearing was in two parts. One was in July and one was in September. All of the same allegations. He's poisoning me, the stuff in South Carolina. Again, they're not even living together. And she fails. The judge in that case says, no injunction. And this man will have immediate visitation with his child, who, by the way, was 6 months old and he'd never met her. It wasn't for lack of trying. There may be a lot of deadbeat dads out there that don't care about seeing their children, that don't want to be around. This man tried everything to be around for his child, to be there for the birth, to visit the child, to see the child. And she kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. I'll go with you. And now we're in a stage where we're acting like we're going to get back together. Because she knew the court system was not working, and she was afraid that if she didn't buddy up to him, he was going to get this child away from her. So it begins the charade of her telling him, we're going to get back together, we're going to be a family. She played on Doug Benefield's wishes. He wanted more than anything to have his family together, to have his wife that he loved and this child all together. And she kept telling him, yes, that's what we're going to do. That's what we're going to work towards. So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. he files for divorce. And a series of complaints start against Doug Benefield for now abusing the child. Which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And May 1st of 2020, the defendant, having failed in the criminal system, again, files for another injunction based on these allegations that fail in the criminal system. Do you see a pattern here? May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens? All of a sudden, she sidles up to him, and now we're getting back together. And we start to go to marriage counseling, and we go see Dr. Forrest, who referred them to Dr. Quintel. And they're going to marriage counseling about how they're going to get together. And to Doug, she's saying, yes, I want to reconcile. Let's get back together. But behind his back to the doctor, she's like, no, I know how. I'm not getting together with him. Then she goes on all these social outings with Doug and the child. Goes to the beach, goes to the movies, goes out to dinner, to lunch, swims at the pool in his apartment complex. Giving Doug all of these mixed signals. We're gonna reconcile. We're gonna get all this back together. And in the back of her mind, she knew all along. She was just waiting for an opportunity to strike. And then 6/1 of 2020, the system sends them for an evaluation with Dr. Broder. And they're like, what is going on here? Someone needs an evaluation. So they go to this evaluation with Dr. Broder, and this deception on the part of Ashley Benefield continues. She does the same thing. We're going to reconcile, we're going to get back together, and then when she's not with him, she's saying that that's not true. And then towards the end of September 2020, but before the 21st, there's a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough. I want the report. I want this to be done. We need to move to Maryland. Why do you think she's moving to Maryland? We need to move to Maryland. This is taking way too much time. And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered. On 9/21 of 2020, after this comment to Dr. Broder, she goes to mediation with Doug Benefield, and they end the mediation saying, everyone's going to drop everything. Because at this point, Doug had filed for a divorce, again. And Ashley had filed for an injunction, again. So at this hearing on the 30th, those things were going to be heard, as well as a joint motion to release a report by Dr. Broder. But they go to mediation, and at the end of mediation, it's very fast, because they all agree. We're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction. Look at the text messages between her and Doug that were introduced by the state for the week before this homicide, murder happened. They're talking to each other about the fact that everything's going to be dropped. Give this attorney a call. Okay, I'll give that attorney a call. Ashley's telling him we're going to drop everything. And she knew that was not true. Her attorney testified, we were not dropping that injunction. We were ready to call witnesses. At that hearing on the 30th, we were going forward. Ashley Benefield knew that day it was over. It was going to be over. Her entire charade was going to be done. This entire get along, go along that she's trying to say was because of domestic violence. She was just trying to fake Doug out. And she knew that on the 30th, her ruse was up. Because if she goes forward with an injunction, what better way to tell someone you're not going to reconcile than trying to get another injunction? So what does this timeline tell us for what happened at the time of the shooting? Okay? It's background, yes. But also, it tells you they did not live together for 3 years before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they hadn't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no. I do want to talk a little bit about domestic violence, and Mr. Ferris testified a lot about this wheel, this power and control wheel. So I want to put it up there. First of all, the overarching umbrella right here is physical and sexual violence. There is no physical violence in this case. There is no sexual violence. There's no allegations of any of this, unless you believe the defendant that the day this happened. But there was never any allegations of physical or sexual abuse. However, it's a power and control wheel. So let's go over some of these things. One of the first categories, using intimidation. So this is, did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. The first year they were apart, they barely even saw each other or spoke. So how exactly was he using intimidation to control her? And there's no allegations of threats during this time. The defendant testified she didn't say that there was anything going on during this time. One of the other prongs is using emotional abuse. Same answer. They weren't together. There was no allegation of emotional abuse. The defendant didn't talk about anything that was going on during this 3-year period, that he was emotionally abusing her. She felt comfortable enough. She even said, I told him when he thought he was going to move in with me, I told him I didn't want to do that. She felt comfortable enough to say, no, you're not moving in with me. But yet somehow he's emotionally abusing her. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine, and she even started a new relationship with someone else. So how is it that Doug Benefield is exercising control over her by using isolation? And then minimizing, denying, and blaming. Well, nothing had happened in 3 years. So was there even anything to minimize, deny, or blame? Nothing had happened. And there was no evidence of anything happening, other than maybe some things that the defendant said happened, but did they really? For instance, Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there, he said he lived there. And somehow this translates to this person is looking into your windows across the street, and the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Did you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really. Then the next spoke on the wheel is using children. This man did nothing but try to see his child over and over and over. Ashley Benefield kept his child from him. So if anybody was using power and control, it was Ashley Benefield against him. And I think if you look at a lot of these folks, you're going to see a lot of behaviors on the part of the defendant that were actually using power and control instead of being a victim of power and control. Then male privilege is the next spoke. There was absolutely no evidence of male privilege. There was an email to the realtor to get a house, just as one example. And if you read that email, he says, okay, but I have to check with Ashley first. How is that male privilege? He's telling this guy he's going to talk to his wife. Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. That doesn't apply. Using coercion or threats. No threats. She didn't say there were any in those 3 years. None. There were no allegations that he threatened her or hit her or did anything. He didn't make any reports or threaten to report her to Department of Children and Families. He didn't say, oh, you better do what I say or I'm going to call DCF and tell them you're a bad mom. No. That was the other way around. That's what she was doing to him. There were no allegations that he was trying to get her to drop charges. Quite to the contrary. She was not dropping any charges of anything. And Mr. Ferris talked at the end of his testimony about domestic victim mentality. So let's talk about this. One of the things in the domestic victim mentality is covering for the abuser. like making excuses, covering for them. Did you ever hear any evidence of the defendant doing that? Never. Making excuses for the abuser, making excuses for their behavior, not once. She was telling everybody, anybody that would listen. Not reporting abuse, same answer. She was telling anyone that would listen and a bunch of people that wouldn't listen. Dropping criminal charges. That certainly didn't happen. The domestic victim mentality, she won't stand up for herself. Never saw that with this defendant. And she won't leave the relationship or the home. She left. She left the home, she left the relationship. They were not together for 3 years. So how does this domestic violence mentality, domestic victim mentality even apply to her? It doesn't apply to her. And don't be mistaken about what applies to her and what does not. Even, like I said before, even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between. So I want to talk to you a little bit about the jury instructions that the judge talked to you about. I just have a few on here that I want to go through. It's got to be overwhelming, I know, when you read the packet. There's a lot of words. So I try to help break it down a little bit. So the defendant is charged with murder in the second degree. So I would recommend the way you go through this is check off the things that you don't have to argue about. If everyone agrees to one of these, just check it off. So number one, Doug Benefield is dead. That should be easy. Check it off. There's no dispute. Number two, the death was caused by a criminal act of Ashley Benefield. Check it off. She shot him. Number three, there was an unlawful killing of Doug Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Now that's a lot of words. So what does that mean? The next slide explains what that means. An act eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, and again, check off things, okay? So a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Shooting a gun, firing a gun into someone clearly qualifies. A person of ordinary judgment would know that would kill someone. Check. Let's go to number three. That this act is of such a nature that the act itself indicates an indifference to human life. Pulling a trigger, pointing a .45 caliber firearm at someone and pulling the trigger 4 times shows an indifference to human life. So then we go back to number two. If the acts are done from ill will, hatred, spite, or evil intent. Now notice, this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files, fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will. Everything she did was for this goal, and everything she did was to get Doug Benefield out of the way. And unfortunately, the way she did that was by killing him to get him out of the way. That is ill will, hatred, spite, or evil intent. Now, the judge read to you that there's something called a lesser included offense. And what you may have heard, but it's in your packet, is the way you should handle a lesser included offense is such. So if you agree as a jury that the state has proven a charge beyond a reasonable doubt, you should start with the highest charge. So start with second degree murder. And if all of the jurors agree unanimously that it's beyond a reasonable doubt that the state has proven their case and the defendant is not entitled to self-defense, then you don't even get to manslaughter. You don't have to go and then review manslaughter. You stop at the highest charge. You only get to manslaughter if you don't agree on the top charge. Then you get to the description of manslaughter. And again, check off the things that you are not arguing about. Doug Benefield is dead, check. Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. Yes. There's no question as to that. Now, the state did prove this, but the state also proved the added element of ill will, hatred, spite, or evil intent. So we have proven manslaughter, but we have also proven above manslaughter. And I want to show you the verdict.
Now, we skipped the parts of the where they were discussing the jury instructions, but she's going through, pay attention to this part because they're both going to go through the jury instructions on the different charges and either point out how they think that it has met it or has not met it.
Form, and then we'll go back. This was the verdict form that the judge showed you, just to let you see it ahead of time. And this is the heading that the judge read. We, the jury, find as follows. As to the defendant, in this case, check only one. And here's A, B, and C that the judge talked to you about. Defendant is guilty of murder in the second degree as charged. Defendant is guilty of manslaughter, a lesser included offense, or defendant is not guilty. And then if you find A or B, then you have to answer all three of these questions. And then the foreperson will sign it and print their name. So the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are two words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony.
Okay, this part's really important because this is going to be the difference in a conviction or not. This specific part, because we have to, I'm so glad I'm not on the jury. You have to remember that it's not about the abuse, it's about feeling justified. I want to rewind that because this is the most important sentence in that whole part.
Necessary in using justifiable use of deadly all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. So let's get to the date of the offense, okay? Clearly, these two are getting along, at least according to Doug Benefield. He thought they were getting along. If you look at the text messages between the two of them, if you go by the information that you had from the witness stand that Ashley was acting nice, she was acting like they were going to try and reconcile in Maryland. They were moving together. They were using the same truck. He was coming to her house to help her move the heavy things. So they were getting along. They actually went to the mediation during this time. It was about 3 days before she killed him. They had mediation where they said they were going to drop everything, move into Maryland, everything's going to be fine. But obviously that was not Ashley Benefield's plan because she knew she wasn't going to drop the injunction. Obviously, the day of the offense, Doug Benefield had a right to be at the house. She invited him over. They had text messages back and forth, trucker on the way, you know, he's taking a picture of the stuff in the back of his truck. And she'd let him in the gate numerous times before. So he had a right to be at the house. She clearly was not afraid, so she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield. And you heard her story. And she made herself a witness, just like any other witness in this trial. And you will judge her credibility and the truth of what she said, just like you do any other witness, and see if it matches the evidence in this case. If you noticed, when being asked questions, she became evasive. If questions got a little too difficult, or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes? Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break, crying hysterically. Takes a stand right after that. Eyes are just fine, makeup's just fine. That goes to her credibility. What is she trying to convey to you? The truth or her version of events? Let's look at what she did say. She said during this move that Doug bumps her on the shoulder a couple times, body check or something. She didn't really act that out very well. Who knows what that was.
Oh.
Doug carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Wouldn't you expect a bruise to be there as well? You'll have the pictures in the back. So look at those pictures and see. There's no bruising. They look like cat scratches. The defendant also said when they were by the front door to the house that he grabbed her by the wrist and hit her in the head. So when I asked her, okay, what do you mean hit? Well, I don't know. Okay, was it an open hand? Was it a closed hand? What was it? I don't know. She should know if a grown man balled up his fist and punched her in the side of the head. And there would be a lot more damage than what she claimed she had. But she didn't know. He just hit her. Now, 4 people testified that they saw her after this incident, very shortly after this incident. Well, one of them was 3 days later, but the rest of them were very shortly after this incident. John Sands, the neighbor, he didn't see any swelling. He didn't see any injuries. He didn't see any disheveled clothes like there'd been a, rumble. Detective or Officer Burrell, Deputy Burrell, was the one that put her in the back of his squad car. No injuries. Didn't notice any injuries to her head or swelling to her face. Crime scene tech Dvorak took pictures. Didn't notice any injuries, any swelling to the face. 3 days later, crime scene tech Conlon takes pictures just to make sure, because bruises don't always come up right away, that she's not bruised. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen. Let's look at these pictures. These are 4 pictures that were entered into evidence. The first picture was, the defendant said, was before she even knew Doug Benefield. She thought it was before she even knew him. The second picture at the top, over on the right, is the night of the shooting. Down lower left is 3 days later. And then one over is about 6 weeks later. Does it really look like her face is swollen? She said the side. She said right here. On the right side. Or, I'm sorry, the left side. Right here. The left side of her face doesn't, it actually looks slimmer than it did in the picture taken before she even knew Doug. So let's talk about what she did when she claims that Doug grabbed, I think she said she was going for the front door. He grabbed her arm. She kind of spun around. He hits her in the head, although she didn't know if it was open hand or not. And then she said, I just wanted to get away. I just wanted to get away, right? Here's the front door, right? She went this way and could have gone right out the door. But she just wanted to get away. She didn't go right out the door. She turned to her right and went into this room. This room that has nothing in it except for a mattress, a broom, and a hamper, and 2 handguns. It's hard to see in this picture because of the lighting, but I just want to remind everyone, here's the mattress, here's the broom, nothing else in this room, but there's a hamper right here with a gun on it, and there's a gun in this closet right here. And that's where she runs. And this is a better picture of the hamper and where the murder weapon was. So she just wants to get away, but she runs into the very back corner of this room and grabs a firearm. Now, she claims that as she's retrieving this firearm, he slams the door open and she turns around, right? And she sees him standing there. When I asked her to get down and show me what he was doing, that was another one of those evasive thoughts. I don't know, he was in a fighter stance. I don't know what fighters do, but I know it's a fighter stance. Okay, well, show me. What do you mean a fighter stance? I don't know, kind of like this. Okay, well, what are his hands doing? Just kind of moving around. Okay, so his hands are kind of moving around, and it didn't look a lot like a fighter stance. And then she said, I'm standing there with the gun pointed at him, and he lunges at me. He lunges at me. Let's think about this. So if she's standing in the room, she has a gun in her hand, and he just came in the door, and she's pointing the gun at him. She says he takes a fighting stance. First of all, he's right-handed. Do this yourselves when you get in the back. If someone told you to get in a fighting stance, what would you do? And determine for yourselves, use your common sense, which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away. So if he's right-handed, he's in a fighting stance, he's going to be like this. Interesting, because he's shot from this side. So he's like this. And then she says he lunges at me, right? So if he lunges at her, he's head on, straight on to her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went. That bullet went side to side. And if he's in a fighting stance and he's right-handed, why would he have this side towards her? And Mr. Haig, the expert, the firearms expert, displayed when I said, okay, I'm going to point a gun at you. You show me where your body would have to be in order to get that trajectory. And he turned sideways. So his body in his fighting stance would have to be completely sideways. And what, he's skipping to her to lunge? I mean, how is that trajectory going to happen based on what she said? More than likely, the hands that were up was a defensive stance. He probably came into the room and said, whoa, she's got a gun, and started to turn around. He had his hands up like, whoa, what are you doing? It makes no sense to be in a fighting stance. So I want to talk a little bit about this trajectory just because there's sort of some misconception that this shot was front to back. That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, the right-hand side, and that red dot is where it landed in the back. And let's talk about the leg wound. It's very hard to determine exactly how this leg wound happened. And we may never know exactly how it happened. But this is the basic trajectory of it if a person were in a normal standard anatomic position. This is the medical examiners said that. This is a standard anatomical position. So in a standard anatomical position, that is the way the wound path went through his leg. So you can figure out for yourself different ways.
They have it covered by this, but you can see that there's the arrow down here.
That might have happened. Now, Dr. Liu said, based on information that she got from Ashley Benefield, by the way, that it must have happened this way. That once he shot the first time, somehow he falls and his legs go way up in the air, and he shot like this. Where did that bullet go? If he was shot like that? The expert testified about the two that went into the wall had not gone through a body. He said the one that hit the leg was in the room. It might have been kicked, and that's normal when you have emergency technicians in there and they're kicking things around. But the projectile was in the room. It was not in the wall. So if he's falling back this way and his leg's slipping way up, and by the way, Dr. Vega said the only way your legs flip up like that is if you're falling over a rail or, falling over something and your legs come up that high. So that just does not make sense with the rest of the evidence. Now, this may not be the way it happened, but it is also another way that it could have happened. He is turned away, leg up, and that bullet could have gone in and come out his knee, but his leg was bent. So you use your own judgment and decide what you think about.
Okay, see, that one is a little bit now it's not hidden by the thing. You can see. I don't know. What do y'all think?
So you use your own judgment and decide what you think about that leg wound. What's important is this wound. This was the wound that killed him, and he was not facing her at the time.
I'm glad I'm not on this jury.
The defendant trying to say he was in a fighting stance, he lunged at me, that is just her, once again, trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance, I don't know if he's still alive. You know, I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And then she sees her mother come by the car. Not once does she say, Mom, he just came at me. Like, I had to shoot him. It was awful. Nope. Not a word. She goes back to her mom that night. Not a word. Really? You're not going to tell your mom exactly what happened? And then this lady, Barbara Russell, that she lives with for 9 months after the shooting, never tells her what happened. Not once. Remember, the defendant sat right there and said the defendant never punched her, ever. Never choked her, never kicked her, never came at her with a knife, never came at her with a club, never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder. Thank you.
All right, Mr. Taylor, do you need the screen?
Not.
I'll turn that off for you.
What do y'all think?
Yes, sir, when you're ready.
Thank you.
What are you thinking? How are we
Good afternoon,
feeling?
ladies and gentlemen? I have a bit of a cold. I tested 3 times and it's not COVID. Don't need to be concerned. I've just listened to the state's closing argument. I have to tell you, I think there's obviously some real different perceptions of what the evidence is. I think perhaps there's even been some distortions. You all have taken, we've observed, pretty careful notes. If I say something that is not reflected in your notes or is not as you recall it, I want you to trust your own recollection. But I think if you check your notes, you will find that what I represent to you is accurate. This is and has been a fundamentally flawed prosecution. And I think we can demonstrate that through the testimony of 2 of the state's witnesses. The first is Stephanie Murphy. And you may recall she was the attorney who was representing Doug Benefield. In my cross-examination of Stephanie Murphy, I served up for all of us, but especially for you, the members of the jury, what the state's theory of prosecution was. And I said, so Ms. Murphy, let's be clear so that there's no misunderstandings. It's your belief in the state's theory that Ashley Benefield killed her husband because the Broder report was scheduled to be released 3 days later. She said that's correct. Check your notes. Now, the state, in their opening statement, even made it dramatic. they said to you, this report by Dr. Broder was to be released on the 30th of September, but she killed him on the 27th to avoid that. If you look at the emails that had been introduced into evidence that reflect the conversations back and forth between Stephanie Murphy, Faith Brown, Miss Benefield's family court attorney at the time, and the judicial assistant for Judge Moreland, you will read in no uncertain terms, black and white, the Broder report was not set to be released on September 30th. Not only was it not set to be released on September 30th, there was not even a day for it to be released scheduled. Stephanie Murphy was attempting to have it scheduled. The JA wrote back in no uncertain terms, Judge Moreland will not hear that. The only thing being heard on September 30th is the domestic violence injunction. The other witness that I think reflects what a fundamentally flawed prosecution this is Detective Gillum. Now, you might recall that Detective Gillum, check your notes, said that the South Carolina domestic violence injunction that required no contact by either one did not go into effect until November 27th. But if you look at the written email that we introduced into evidence, where Detective Gillum is contacting Gina Torsha, Miss Murphy's assistant, Detective Gillum tells her, wait a second, he's helping them. Wait a second, this injunction, unless I'm reading this wrong, this injunction went into effect on November 3rd. The judge signed the order on November 27th, but on November 3rd, he announced it in open court, and Doug was present, and so was Ashley. So unless I'm reading this wrong, I want you to be aware of that. This is Gillum trying to help them. This is the same Gillum who gives you quotes of exactly what Ashley Benefield said 2.5 years later without having one word of it written in his earlier report. The same Gillum who I asked the following questions of. Detective Gillum, do they teach you in police academy about the importance of writing reports? Sure. And is the reason why the reports are so important is because it preserves important facts about a particular incident? Yes. So how many cases do you handle, Detective Gillum, in a month? You might recall he said, probably about 20. And then we multiplied that out by 2.5 years. I think we were into about 600, 700 cases. Yet he remembers the exact words she had to say, despite the fact that on the day she said it, not one word of it appears in his supplement 2.5 years earlier. Ladies and gentlemen, Detective Gillum, you might also recall, countermanded the capias, the arrest warrant that the other deputy issued for Doug Benefield when Ashley went down there and explained that Doug Benefield had mailed her this package in violation of the South Carolina restraining order. Detective Gillum said he remanded it, he reversed it, and he was going to refer it over to the state attorney's office. This was a good old boy network. They liked Doug, and they never looked back. And that's the truth of the matter. Do you not find it astounding that Detective Gillum, 2.5 years later, could remember such things as Ashley Benefield saying, if the judge sees you arrest him in front of her, it'll help me keep my baby? Isn't that something that you would put in a report? I think perhaps the most disturbing thing about the testimony of Stephanie Murphy and Detective Gillum is the following. Remember that common sense I told you about that you're going to be able to take with you back into the jury room, and that without offending anybody, there would probably be more than 100 years worth of it, which there is? Does anyone believe that either side calls witnesses that they don't know what they're going to say? So how do you reconcile the state calling Murphy and Gillum knowing that they're going to testify inaccurately? Read Gillum's written email about how he misrepresented his knowledge of when that South Carolina domestic violence injunction went into effect when he testified in front of you, and read the emails between Stephanie Murphy, Faith Brown, and Judge Moreland's judicial assistant. Okay, so what happens after that testimony? I want you to remember that the state's theory of prosecution up to that point is that Ashley Benefield killed Douglas Benefield to stop the release of the Broder report because she was so afraid of what was in it. And right in front of your eyes, I've never seen it before, right in front of your eyes, the state changes their theory, and the next thing you know, their theory of prosecution is she killed him because the domestic violence injunction was scheduled 3 days later. Check your notes. See if what I'm telling you is not accurate. Both theories, honestly, are ridiculous.
Objection, Judge. Sustained on that.
Both theories are not supported by common sense. Let's look at Broder. What exactly was it in Broder's report that Ashley Benefield was so afraid of that she killed Douglas Benefield? Check your notes, but try to think back to Broder's testimony. I think your notes will reveal that Broder never had one thing adverse to say about Ashley Benefield. In fact, the only thing that Broder had to say was that after evaluating Ashley Benefield, he found that she had no violent tendencies. She was not prone to impetuous acts. That's it. Her only concern, according to Dr. Quintel, was that she was afraid if Doug found out what she had to say about him, that he would take it out on her or on the child. Okay, let's look at the theory then when it shifts to it being the domestic violence injunction that was scheduled for the 30th of September. What kind of reason exactly is that for her to kill Doug Benefield? If that was a reason, wouldn't she have done it before? There was already a domestic violence injunction the first time. It was denied. It was not only denied, but Judge Moreland ordered shared custody of the child. Why wouldn't she have killed him then? For 4 years, Ashley Benefield did what any law-abiding citizen can be expected to do. She filed complaint after complaint after complaint, calling Doug Benefield's behavior to the attention of the authorities with no result. Over and over again. No relief. So she kills him? Really, that's quite a leap, ladies and gentlemen. You need evidence to support such an inference. You know, you can't take innuendo and wrap it up in an inference and call it a fact. You got to have evidence that supports a theory. For example, you know, in the reasonable doubt instruction I'm going to show you in a minute, but it says a reasonable doubt can arise from the evidence, from the lack of evidence, and from a conflict in the evidence. So what evidence would you need to show to support this theory that flies in the face of common sense? Well, how about somebody who comes in and testifies, yes, I heard Ashley, I overheard her say, you know what, I'd kill this SOB before I'd let him be alone with my child. Or how about this? How about downloading from Ashley's phone when she's sitting there in her most private moments, never expecting it to be revealed to the world, searching on the internet how to kill an abusive spouse? How about that? Instead, what you saw in her most private moments, 6 months before this happened, was her searching on the internet how to co-parent with an abusive spouse. Am I making this up? Check your notes. How to get along with an abusive spouse. In my opening statement, I told you two things. I said that at the conclusion of the case, those were the only two things that would be established beyond a reasonable doubt. The first one was that Doug Benefield was a very sick guy. I think there's no doubt of that. The second thing was that Ashley's action on that day, September 27th, 2020, was absolutely justified. Let's take a look briefly at Douglas Benefield's behavior. And I want you to keep in mind Bruce Ferris's testimony, who's the former cop who specialized in domestic violence, ran a domestic violence department, and then was so fascinated by it, went back to school to become a licensed mental health counselor. I thought he was a pretty persuasive witness. Doug Benefield shoots a gun into the ceiling of their kitchen to intimidate Ashley to stop speaking. Now, those are easy words for me to speak, and they fall on ears and you move on to the next thing. But I want you to try to imagine how it would feel.
Objection.
Sustained.
You can't ask the jury
How would one
to.
feel sitting in their kitchen, having their husband pull out a gun and actually fire it into the ceiling of their kitchen? Can you imagine the trauma of such a statement? Do you think that that's something that you forget about after 6 months, after a year? I think that's something you remember for the rest of your life. You never forget it. Throwing a loaded gun at Ashley Benefield, threatening suicide, not only to Ashley, but to his former wife, Renee. You've got a copy of her text message that she wrote to Doug, kicking her on their honeymoon and threatening suicide. So this is twice now, not only with Ashley, but with his prior wife. Punching the dog so hard that he knocked the dog unconscious. Bruce Ferris on the wheel. Now, I'm not an expert on the wheel. I don't pretend to know it anywhere near as well as apparently Miss O'Donnell does. But I can tell you with certainty that it has a provision, and Bruce Ferris elaborated on the fact that abusers tend to hurt pets because they have no empathy, and because, check your notes, they can control the victim because the victim loves the pets. So hurt the pets, you keep the victim in line. You get compliance, control, and compliance. That's what they seek. Threw the cat down the stairs. Put a tracker on her car. The neighbor catches him in the yard at night. It wasn't in the house across the street. You've got the schematic of the houses in the neighborhood. You see Mr. Sand's house is right next door, literally, to the left of Ashley's house. Ashley's house has got the red dot on it. Cursing, yelling, screaming, belittling. Text messages. I'm in a murderous mood. I want to rid the earth of them. Take them out. That was about two guys having a conversation while Ashley was on a cruise. Doug Benefield was so demented that just hearing in the background two men speaking while Ashley was on a cruise makes him say he wants to take them out, rid the earth of them. That puts him in a murderous mood. Of course, Ashley at the time at 24 thinks, well, gee, that's kind of flattering. I guess this guy really loves me. Oh, that was just a little tip of the hat to what was to come. The South Carolina injunction, he violated it. There's no way around that. How about driving from South Carolina to Florida so that you could follow Ashley in the car? I mean, if that's not determination, what is? If that's not fixation, what is? If that's not obsession, what is? And most chilling, I thought, was Mr. Vincicaro, the realtor, who, while the injunction is in effect from South Carolina, look at the email between Doug Benefield and Vince Vincicaro. I asked him, did you have any dealings with Douglas Benefield? Yes, I did. What was it? He was a customer looking to buy a home. Where was that home? It was the house immediately behind Ashley Benefield's house. This is sick, ladies and gentlemen. This is while the domestic violence injunction is in effect. Not only that, but then he says to Mr. Vincicaro, well, I have to first check with Ashley. Well, you know that's a lie. He can't check with Ashley because the injunction doesn't allow him to communicate with Ashley. So what's the basis for that conclusion that Doug was that disturbed? Well, how about Doug's own admissions? You have the text messages where he admits to Ashley, you know, I'm sorry, I apologize. And according to Miss O'Donnell, well, that should be the end of it. You apologized, it's over. Unfortunately, Bruce Ferris explained to you that that's the MO of an abuser. Oh, baby, I'm so sorry. Please forgive me. It'll never happen again. And it happens again. Time and time and time again. That's their pattern of behavior. And Bruce Ferris told you that. He explained that to you. Ashley Benefield got on the stand and told you about all of that. And I have a great discrepancy. I'm wondering if we were at the same trial between Miss O'Donnell's evaluation of Ashley's testimony and ours. But how about this, in addition, as a basis to establish how disturbed Doug was? How about the letter that Ashley Benefield leaves for Doug on November 17th?
Objection, not entered in evidence.
Sustained.
Judge, I was testified to by Miss Benefield. I'm just speaking to the letter, not quoting from the letter itself.
Okay.
So she told you that she left him a letter. She told you what she put in that letter. That letter recounted some of the things that he did. Some of the things that you heard about in the trial, such as shooting the gun, punching the dog. So, how about that as a basis to support it? She described them as controlling and manipulative. You're putting me and my unborn child in danger by the way you drive. You drive crazy when you get angry. How about Dr. Quintel? He doesn't even have a dog in this fight. He's got absolutely no reason to shade his testimony one way or the other. What did he tell you that he concluded about Doug? That he was, quote, super controlling, unquote. That he was jealous. That he was intimidating. That he was a real alpha male. Dr. Quintel's description, not mine, ladies and gentlemen. And then we have Ashley, who's the victim of domestic violence. We have the history of the prior acts of domestic violence by Doug. According to Dr. Broder, the state's witness, and Bruce Ferris, our witness, victims of domestic violence look for appeasement. Dr. Broder, I even asked him, I think that word appeasement appears in your report about at least 4 times. They go along to get along. They walk on eggshells, always afraid that something they might say will set them off. And according to Bruce Ferris, what the abuser wants is compliance. That dynamic changes very significantly once a child is introduced into it. And why is that? Because the abused woman is going to look to protect her child. That's what mommies do. So she will put herself in danger in order to stand between the abuser and her child. Yet, Ms. O'Donnell argues, well, when they first exchanged custody, as Stephanie Murphy said, Ashley looked happy and very content. Well, we know from Bruce Ferris that that's the compliance mode. That's what you do to protect your child. She knew how Doug was. He went off on her. The only thing worse than that would be him going off on Emerson, the child. You keep the beast at bay. Those were the words. of Broder and of Bruce Ferris. Importantly, Bruce Ferris told you that victims of domestic violence appear to act happy. So you have these text messages in the week leading up to the shooting where they're saying nice things to one another with emojis and smiley faces. And you have the video of the restaurant where Ashley and her mother and Emerson are present, and Ashley appears to be acting happy, when in fact she's actually quite scared, according to Bruce Ferris. But you go along to get along. You might recall in the voir dire, I asked you about the presumption of innocence and how many of you had ever seen a cop car on the side of the road with somebody sitting in the back. And the first thing you thought to yourself was, gee, I wonder what they did. Caused them to be in the back of the squad car. And I told you that the issue to be resolved in this case was going to be, was the force used justified? All of you pledged that if the state failed to prove their case beyond a reasonable doubt, your verdict would be not guilty. All of you took an oath that said, at the end of the case, if you were unsure, if you did not know what happened, if you did not have an abiding conviction of guilt, you'd vote not guilty. I want to show you the beyond a reasonable doubt instruction. Deputy, if I could have the easel, please.
Yeah, and that's very common, Kelly P, in public where they're totally different person.
This is in your packet of instructions. You're not going to have to memorize it. I want to just go over it, though, for a moment. I think we can agree it's pretty important. It reminds you that the state has the obligation and the burden to prove the case, to overcome the evidence to the exclusion of and beyond a reasonable doubt. And here's how they define reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, goes back and forth, gee, I don't know, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must, not you can, ladies and gentlemen, not you may, you must find the defendant not guilty because the doubt is reasonable. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. Thank you, Deputy. Let's take a brief look at the facts rather than theories. Because once again, the prosecution could not have been more clear. Ashley killed Doug to prevent release of the Broder report. So, where was the evidence to support that theory? You can't simply say it and make it so. Ms. O'Donnell comes up, and the evidence that she presents to you to support that theory is that Ashley said, I'll take matters into my own hands. Ladies and gentlemen, Dr. Broder testified that Ashley made that statement on her way out of his waiting room. And I asked him specifically about it. Please check your notes. What was she referring to? And he said, going to the authorities in Maryland to seek relief from them because the system here had failed her, and she was very frustrated. Ms. O'Donnell also told you that Doug Benefield filed for sole custody of Ashley. Please check your notes. No one ever testified to that. There's absolutely no evidence in this case that such a thing was done or a statement was made. Other evidence in the case? Justin Warren, the lead homicide detective. State never even called him.
Objection.
We called him. What did he tell you? He told you that in his arrest warrant, he said it did not appear that Douglas Benefield was facing Ashley Benefield when shot. Now look, Dr. Vega came in here and testified that the shooting in the chest, the shot to the chest, was from front to back. Yet Ms. O'Donnell comes up here and distorts that and tries to tell you that it wasn't from front to back. It was from side to side. Dr. Vega told you the trajectory of the chest shot was front to back, right to left. Now, not only did Dr. Vega tell you that, Michael Haig told you that, front to back. Dr. Liu told you that, front to back. There has never been any evidence introduced in this trial that the chest shot or the arm was anything other than front to back. Detective Warren told you he did not speak with the medical examiner before he submitted his arrest warrant. I showed him his report to refresh his recollection. Oh, yes, I did speak to the medical examiner. And finally, I asked Detective Warren about a supplemental report that he wrote where there's a section that provides for any bias that he was aware of that Ashley would have had against Doug. And the form was written none. And I asked, is that not where you would write in things like ill will, hate, or spite?
Hey, Brooklyn.
Mike Haig, let's look at his testimony for a minute. I think you'll remember him. What he said, I thought, really presented it well, was in explaining what forensic meant. He said it's the juncture where law meets physical science. Okay? So he told you there were 4 shots. He gave you a 3-dimensional diagram, and it showed you the room and how the shooting took place and where the shots went. One shot, according to Michael Haig, went out the door and down the hallway and lodged in a book. He described it as a miss. One shot was in the wall. Told you it was a nice round hole in the wall. They put a trajectory rod in it. One shot was in Mr. Benefield's chest. It was lodged in his back. Dr. Vega removed it. And one shot was in the leg. The state's own witness, crime scene people, told you that the shot to the leg was on the floor in the room and that a piece of it had broken off. And Haig told you that as well. According to Ms. O'Donnell, if you completely suspend the explanation that Dr. Liu gave you about the shot to the leg, if Douglas Benefield was running away, that's how you could get the shot in the leg. You might remember that the trajectory or the wound path to the leg was up. Ashley would have had to have been lying on the floor to shoot up so that the bullet would go in the calf. Dr. Liu explained to you exactly how that happened. We even had our summer law clerk, William Galvano, come here and demonstrate.
It's a problem.
I've never seen this many objections in a closing.
Michael Haig tell you that was significant. He told you that they were moving. He said both Douglas Benefield and Ashley Benefield was moving. And he even showed you how it went from right to left in that 3-dimensional diagram with the first shot out the door, the second shot in the wall, or one shot out the door, one shot in the wall. one in the chest and one in the leg. He showed you the two different cones. That would be consistent with what Ashley told you about trying to get more distance to move away from him. There was only one way to go in that room. She was already back to the back of the room, so the only way she could go was sideways, to her left. Finally, he also told you that Ashley's explanation was absolutely consistent with the physical evidence. Then we had Dr. Lou, Emma Lou, former medical examiner for Miami-Dade County, who has always testified for the state. Except here, she came in and testified for the defense. Why do you think that is? Dr. Lou told you that the abrasion to the arm, she believes, was from front to back, and she believed it was the shot that went out the door and down the hall. And the bullet would not have mushroomed or expanded, as you heard Michael Haig explain, that bullets are designed to be able to expand. Because the wound was so superficial, there would not have been enough tissue in the hollow point of the bullet to expand it. She also told you it would be consistent with Doug lunging at Ashley Benefield. And she showed you with rods how the abrasion to the arm would take place, as well as the shot to the chest. Now here's something interesting that maybe everybody's forgotten, Miss O'Donnell did not address. Who was it that told us that Doug was skilled in martial arts and trained to take the weapon away? Why, that was his daughter, Eva. So here's Doug, who gets into his fighting martial arts position and lunges at her to grab the weapon, and Dr. Lou explains the abrasion shot. All four of these shots had no pattern at all. These are four random shots, no association whatsoever, indicative of somebody who's in an absolute panic firing a gun. What's more, as not only Mr. Sant told you, Mr. Haig told you, and as the state's own witness told you, if you don't hold the weapon properly and give it the pressure that it needs, it will result in a jam from one of the cartridges, just like what happened here. So I want you to please consider something. Before evaluating the defense case, you have to first determine whether or not the state failed to prove that the shooting was unjustified. That's your first order of business. Because if the state failed to prove their allegations beyond a reasonable doubt, it's over. You don't need to evaluate the case that the defense presented. We weren't obligated to present anything, but we did. And I think we can agree that if the state's case does not meet that threshold of beyond and to the exclusion of every reasonable doubt, your verdict must be not guilty. Ashley Benefield got on the stand and endured over 2 hours of cross-examination. It was our perception that the state never landed a blow in over 2 hours. That's 2 hours in addition to the hour and a half that I had her up there on direct examination. In the world in which we live, it sounds strange to try to reduce an event like this to an explanation within an hour and a half. But this is the only forum that we have to resolve things like that. So we did it. And Ashley got up there and she explained to you exactly what happened. And she did it well. And the state never touched her. Look at the crime scene photos that were taken, not at some modeling presentation, not at some outing. Look at the crime scene photos that were taken by Miss Dorvac. They're in evidence, and you see if you don't see swelling and redness on those photographs. So it's September 27th, 2020, the day of the homicide. Doug arrives at Ashley's house late that afternoon, and he's already simmering. He's on a slow boil, ladies and gentlemen. Why? Because he knows she's leaving. She's leaving. He's not going with her. He's going to live somewhere else. He knows that. This was his last hope for any kind of reconciliation. And Bruce Ferris told you that the most dangerous time for a domestic violence victim is when the abuser recognizes that she's leaving. So how does Doug respond? With threats and intimidation. He would not leave. Ashley tried to de-escalate it. She could see how he was starting to build. She wanted to avoid a confrontation. Gee, you know, Doug, we pretty much got everything done. Why don't we quit for the night and we can continue tomorrow? He ignored her. Instead, his hostility starts increasing. 2 body checks where he bumps her shoulder, passing her in the hall. And it's not a bump that's an accident. It's a bump to intimidate her. She told you she almost lost her balance. Then we have the cardboard box incident where he slams that into her. Once again, she tries to de-escalate it. She even apologizes to him. And I asked her, why in the world would you apologize when he was the one who hit you with the box? Well, shortly after that, Ashley's had enough. What does she do? She tries to leave. She tries to flee the house. He catches up to her, grabs her by the hand, whirls her around. His back is now at the front door, and he's got her blocked. Somehow, Ashley finds the inner strength to yell, "I'm done. You need to leave now. I'm done. You need to leave now." Please check your notes. That's going to be real important. Why? Because that revoked Doug's permission to be in Ashley's home on that afternoon. And here's what the instruction is going to tell you about that. It's in your packet. It's going to say the law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, I think we can all agree this was her home. Doug did not live there. He was there by her permission on that day to help pack things. She had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1, Douglas Benefield had permission or consent to enter the dwelling or structure owned by or in possession of Ashley Benefield. 2, Douglas Benefield, after entering the structure, remained inside after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure. The offense was false imprisonment. Ashley tried to leave her home. Doug stopped her, spun her around, and held her trapped inside the house. Or B, attempt to commit a forcible felony. Forcible felony is aggravated assault. Through threats and intimidation, Doug committed the offense of aggravated assault. It's in your packet, read it. The important point is that once Ashley says, "I am done, you need to leave now," he becomes, in essence, a burglar by remaining in that house after she tells him to leave. Not my words, not my law, the law that Judge White has given you. The last witness that we saw was Amy Carlton. And you might wonder how Miss Carlton fit into all of this. Well, actually, she played a very significant role. We called Amy Carlton to show that this was anything other than a staged event. If you accept Miss O'Donnell's interpretation of this, it was a staged event. It was a setup. Miss Carlton told you that she was out walking her dog with her husband. They heard a series of shots. And less than 30 seconds later, Ashley emerged from the house, hysterical, screaming, holding the gun, and ran right next door. If you're going to stage an event like this after the shooting, you're going to certainly check the scene to make sure it's going to support your version of the event. Because if it doesn't, you're on your way to prison. It's going to take you longer than less than 30 seconds to do that. The state has failed to prove anything here beyond a reasonable doubt. We prove self-defense beyond all doubt. But the burden is not ours. It's theirs. And they must prove it beyond and to the exclusion of every reasonable doubt, which, ladies and gentlemen, they just have not done. So, for the last several years, I've walked hand in hand with Ashley.
Objection.
I'm now going to surrender her fate to you. I've presented to you everything that I possibly could to show you the dynamics of what took place on that day and why they took place and what Ashley knew about Doug at the time they took place, to show you that her action in using deadly force was reasonable. The judge is going to tell you in your instructions you can take into account what she knew about the domestic history with Doug, the size differential between Doug and Ashley. Ladies and gentlemen, Ashley Benefield is not guilty of murder in the second degree. She's also not guilty of manslaughter. When you read the manslaughter instruction, it tells you that it is not manslaughter if the shooting was justifiable, if it was in self-defense. The manslaughter instruction tells you that as well. You all promised in voir dire that you would stick to your guns and not be intimidated by the majority or the other jurors. Manslaughter is a compromise. Ashley's not looking for a compromise. She's entitled to more than that. This is either second-degree murder or it's not. If you follow the oath that you took and you read the instructions, we're confident you will return a verdict of not guilty in this case. Thank you very much.
Thank you, Mr. Taylor. Rebuttal?
What are we thinking? How are we feeling?
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times. And why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Gillen remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make him. That's what she told a law enforcement officer. You think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did. Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that. I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did, with 45. And let's talk about what we've heard. And it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory. But I want to set some groundworks. Number one, Ms. O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then they wouldn't have. And that's why they did it. That is not an old boy network. That is how our country works. That is what the law is for. Otherwise, Any woman could walk into any police station and say, my husband did XYZ, and they're just going to arrest him? No. It requires evidence. It's the same reason that law enforcement took a long time between this murder and her arrest. They were investigating it. They were making sure they had everything they needed to have. And when they did, they effectuated an arrest.
I was just thinking that, Amanda.
And the prosecution, you heard a lot. You heard Miss O'Donnell's name more than Ashley Benefield's name during that closing. It's not about Miss O'Donnell. It's not about Miss Friel. It's not about either of us. It's the state of Florida, and we have the burden. And we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield so she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Miss Murphy and her client, who was murdered just a few days later, thought that Mr. Broder's report was coming out. Clearly, Faith Brown and Ashley Benefield thought or knew that they were having an injunction hearing on that day. The jig is up. She has wanted this man out of her life. She has wanted her baby to herself. And what is she doing? She's so scared of him, she has him doing her manual labor. You can come over. You can move my stuff. You can get the heavy stuff. You know what? Can you stop and buy me boxes? Can you stop and buy me tape? Do you want to go to the gardens? She told you that she couldn't dress a certain way. She was in a sports bra and shorts when he showed up. You didn't hear that he said a word. You didn't hear that he had insulted her in any way. She would have you believe all these things about Mr. Benefield. And mind you, Mr. Benefield is not on trial. Ashley Benefield's on trial. Ashley Benefield's the one that committed a criminal act on 9/27, 2020, when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding of what was going to happen. There's certainly no dishonesty by Detective Gillum. Not remembering something or Detective Warren and being dishonest are two wholly different things. And nobody's expected to remember everything. The question for you, as Ms. O'Donnell said, is whether or not it was reasonable and necessary for her to kill him, for her to shoot him that day when he's in a shorts and a t-shirt and flip-flops doing her work for her. And keep in mind, this ninja we've heard of, 5'9", 169, adult small t-shirt. Adult small t-shirt, size 30 waist. We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. One of the biggest being trying to maintain this relationship. It ended in his death. But was it reasonable? Never hit her. She said he never hit her. He did some outrageous things, but never hit her in any sort, way, shape, or form. And 3 years they've been apart. 3 years. Reasonable. Is it reasonable? She would have you believe that, and look at those text messages. Look at the text messages going into that week, that whole week. And look at, I would ask you to read the state's version because that is the complete conversation. Oh, I'm sorry, those are the older text messages. When you look at the older text messages, this murderous intent, he's talking about her old boyfriends. She admitted that. And them choking her during sex. He's not talking about wanting to go out in the world and murder people. He's certainly not talking about her. It may not be what the average person thinks of a way to express your love, but apparently to Doug Benefield and to her, it was. So she's like, I know, baby. Don't talk like that. She never checks him, right? She never says, oh, don't. She says, I think she says, it was just a fight. These men that were just talking, she says it's a fight. So don't be confused. Look at the evidence. But in the text messages leading up to that week, look at them. You have them. They're the ones Ms. O'Donnell did that had the video of them playing a game at Panera where they're all yucking it up. I would dispute that she was afraid. I would dispute most of what Mr. Ferris said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse, 3 years, he's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child to terminate his parental rights. And no allegations that he insulted her, came to her house and hit her, did any of those things. Shot any guns, had any guns, none of that. Right? So she did all those horrible things. If you want your baby, those are horrible. To Doug Benefield. She did all those things, and nothing happens. But this day, when she has been dictating for a week when he could come over, when he could help her, what they would do, she would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There's no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keep in mind, she saw her the night of. This is her. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her, this woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them. Till the cows come home, you won't see swelling. All those law enforcement officers who are trained to look for that, crime scene techs who went there for the sole purpose of finding injuries, and had some lawyer pointing out that her ear was red. Look at that picture. There's no redness. No redness. So he becomes so enraged that he hits her for the first time. She doesn't go down. She didn't say I fell. This man is a trained fighter who's a ninja, and he hits her, and she doesn't go down. And she can't tell you if it was a slap or a punch. There's a big difference. There's a big difference. And if he punched her in the eye, her eye would look way different than it does. There's no swelling on the side from a punch. She'd have a black eye. Not a bruise, not a swell, nothing. So let's say it was a slap. Let's believe her. It was a slap. There's no redness, no swelling, no bruising, no scratching, no evidence in the photos. I mean, if somebody slaps somebody in the face, there's a red mark. Nothing. Within minutes. And even if you don't believe law enforcement, which I submit there's no reason to not believe them, Mr. Sand, that sweet old man who she brought this drama into his home, said, I didn't see any injuries. Wouldn't he be the one in the best position to see if she had been slapped in the face moments before? Certainly. He didn't see it because it wasn't there. It's an attempt to manipulate the system, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together, and it was fine. It was fine. So he gets so enraged and pops up and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. Is that reasonable? It is not. And I'm trying to think of a way to say this nicely, but I would submit to you that everything that Dr. Quintal said about Doug Benefield was basically Dr. Quintal talking with Ashley Benefield's voice. She's a manipulator. She manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are. Right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things he conceded that they were all based on what Ashley told him. Not based on anything he observed. He conceded that, which I appreciate. But the weird thing was that he had this weird encounter where he thought that Doug didn't want to see the child. And what did he say? I saw him for a few minutes in my waiting room. I went into a session for an hour. And then I saw him for a few more minutes, and then we started their session. So what happened in that hour? Dr. Quintal doesn't know. For him to make any assumptions on what the relationship was between Doug Benefield and his child based on seeing him for those few minutes is not reasonable. There was no basis for that. And keep in mind, through all of that she's dictating when Doug can see that baby. We don't know if he knew she was out there. He's sitting in the lobby of a psychologist or a therapist's office. We don't know that he knew she was out here. There's so many assumptions the Dr. Cantel jumped to in order to say those things, and they're just not reasonable. Despite a court order, she's dictating when Doug sees that baby and how, and then you're supposed to believe that it was something weird about Doug that he didn't go out to the parking lot. He could have been in the parking lot for an hour for all Dr. Cantel knows. And you know, the one thing he did say that was interesting was Ashley said she was frustrated with the system, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. She tried to terminate his parental rights. The judge said, he can see that baby. That 6-month-old that he's never seen. So what did she do? Well, I don't really want him to do that, so I'm going to dictate how he sees the baby. Now I'm going to be sweet again. Now I'm going to go back. I think the only person that was in a cycle was Ashley Benefield. I'm not going to talk to you for months, but when somebody says you can have my baby, now I'm your best friend again. That's not Doug Benefield. He acted the same way in those text messages as she told you he did for 3 years. No violence, no threats, no manipulation, no emotional abuse. And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship. He would not concede anything. On direct, Mr. Taylor was giving him hypotheticals that had 6 or 8 aspects to them. And he was able to just answer. Oh yeah, sure, that's domestic. Goes right on the wheel. I'm asking him simple questions, and everything he would not concede. The only one he conceded about was that if she was living on her own, he couldn't have been economically controlling her. But how do you not concede that one, right? That's common sense. Every other thing he refused to concede. And this is one thing I will agree with Mr. Taylor. We have different perceptions because I think Dr. Ferris was clearly biased based on his inability to answer my questions when he clearly could answer the defense questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's the victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. And keep in mind, Mr. Ferris would have you believe that somebody could be violent and then never be not violent again. That's what he said. I said, are you telling me that once there's violence in someone, it can never be changed? Well, if that's true, why does he teach CBIP? He makes his money on CBIP, right? Certified Battery Intervention Program. If what he told me was true, he's wasting people's time because he doesn't believe anybody can get better. And we all know that's not true. People change. People learn. People realize what they've done. People apologize for what they've done. And while saying the words is not enough, 3 years of not being in any way violent or threatening or abusive, that's an indication that Mr. Benefield was trying to change. He was trying to do anything he could to be with his wife and to be with his baby. And Mr. Taylor the defense kept saying trauma. She was so traumatized by this gunshot in the ceiling. So she had a baby with him? She testified to you that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said, you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. All the while, she's so traumatized. I would submit to you that is not the case. She wanted a baby, and she got one. But Doug was in the way. And as to that neighbor thing, it wasn't Mr. Sam. I don't know where that came from. There was no allegation it was ever Mr. Sam. It was some neighbor across the street. And Ms. O'Donnell told you exactly what was in evidence. Somebody across the street saw some man in her backyard wearing a baseball cap. And clearly that must be Doug Benefield looking in Ashley Benefield's windows. That's ridiculous. That's a jump you cannot make. That man could have been looking for his dog. We have no idea. There's certainly no evidence he was looking at anybody's windows other than the defense counsel saying that. And even if he was, does not make it reasonable and necessary to shoot him. It is not a basis that would cause you to believe he's going to kill you. Going to kill you. Not a basis. I would suspect you he never was in that yard. He was never looking in the windows. But even if he was, a tracker, not a basis to believe he's going to kill you, if that even happened. The house. Buying the house. I read that very differently. First of all, he wasn't trying to buy. He was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that that mutual injunction was, I'm sure, Miss Benefield was speaking to him when it was convenient for her. But she could get something out of it. It only goes with the rest of it. This letter we've heard about, that Ms. Benefield testified all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did.
I have the letter. It's dated.
I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Lou and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Lou when it comes to trajectory. He's an expert, no doubt about it. That's what he does all the time. Dr. Lou, the medical examiner, she seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why would she do that? She did that because she's getting paid. She's getting paid to be here. That's why she's here. That's why she's saying those things. And most of them are probably very accurate. So Mr. Haig tells you there's 4 shots. We know that, right? We had 4 casings. We have 4 projectiles. One is in Mr. Benefield's chest or back. And I think there was some misunderstanding of what Ms. O'Donnell was trying to show you. What she's trying to show you is that if it was from the front, because say I'm lunging, it would go in my chest and out the back. That's not what happened. It went front to back because it hit in here and came out here. Well, that's front to back. That's not front to back like it goes in my chest and comes out my back. That's front to back because it didn't end up here, right? Or she didn't shoot him in the back, it ended up on the other side of his back. It goes across his body, destroying his lungs, destroying his spinal cord, damaging his ribs. And what did Dr. Lou say? He dropped. He dropped. I think that's important. So Mr. Haig said there's 1 bullet, right? We got 4. 1 is in his chest, so we know where that one is. 1's in the living room wall that Mr. Haig said he believed was going down and struck the tile and then bounced up and hit the wall. He knows better than me. Seems reasonable. 3 is in the wall, number 7. Perfectly round. Typical gunshot. Nothing in its path, because what did he say? If something was in its path, it would begin to tumble. It wouldn't be that perfect hole that we picture as a gunshot in a wall or a target or anything else. And then through his leg. So which bullet hit his arm? And I think Dr. Lou might have been correct when she had that young man laying on the floor. It probably went through his leg and he was on the floor. Because Ashley Benefield told you something. She said, she's shooting down. We know that's not true, right? Because his chest is way up here. His chest isn't down here. But she told you that once I had stopped shooting when he fell. That's also, I think, untrue. Dr. Lou told you he would have dropped. So he's paralyzed, laying on the ground, and she continues to shoot at him. Otherwise, if you believe that she's moving from left to right to get away from him, he's dancing around dodging bullets. I mean, they'd have you believe this is a very tight room. I don't know how tight it is, but you can see there's either a full or a queen-size mattress in that room, and there's plenty of other room. This is not a broom closet. This is a full-size bedroom. And what else do we know? Dr. Vega said that they had to been at least 3 feet apart. 3 feet apart. Uncontroverted. Nobody said anything different. Except for our firearms guy. He talked very fast. But said he looked chemically at the shirt and found nothing. 6 to 7 feet. 6 to 7 feet. Even if we go 3 feet, you have to keep in mind, that's from the end of the gun. She is pointing a gun at him. Here to Mr. Benefield is at least 3 feet, if not 6 to 7, when she hits him in the chest. At least 3 feet when she hits him on the leg, because Dr. Vega said there was no stippling on the leg. They're not in close combat. We keep hearing about this close. They're not in close combat. They're a whole grown-sized man apart, 6 feet, from the end of her gun to his body. And we know that. That's from the science. That was uncontroverted. You heard nothing to question that. You can take that one to the bank. And I would submit to you that those two experts, Mr. Haig was the one you should be depending on, even though he also spoke to Ms. Benefield, so clearly got one side of the story, or a made-up story. And that Dr. Liu is not the expert that Mr. Haig is on trajectory. So if you go in the back and you're curious about the trajectory, I would say you should depend on Dr. Vega's testimony about how the bullets entered the body and exited, which Dr. Liu did not contest. And as for the other bullets, you should depend on Mr. Haig, because he was clearly more suited to answer those questions. As to Detective Warren, poor Detective Warren, who gets called just to be impeached, said he had opinions. You know whose opinions don't matter in this case? Detective Warren's. Mine don't matter, Ms. O'Donnell's don't matter, defense state attorneys don't matter, your opinions don't matter. It's when you go in the back and you listen to the facts and evidence in this case, and you decide if we've proven our case. If Detective Warren, at the time in which he made his decisions, thought that he was shot in the back, that's not wholly unreasonable. He may have been mistaken. It doesn't make his opinion invalid, but what it does, it's not relevant to your decision making, because you're depending on the facts, and you have the accurate facts.
You have 10 minutes.
Thank you, Judge. I appreciate that. And that whole bias business, Detective Warren explained what that is. That's sexual bias or racial bias. This wasn't a hate crime. This wasn't a crime because somebody hates somebody else because of their sexual orientation. That's not what this is. That's not a place to put ill will, hatred, spite, or evil intent. Ill will, hate, spite, or evil intent is not bias. It's an element of second-degree murder. It's a depraved heart. And that's what Ashley Benefield had when she murdered Doug Benefield. A few more things, and then I want to talk to you lastly about the reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I don't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland, because then who's going to move her boxes, right? I can't say in front of Doug, I'm not moving to Maryland with you, because then maybe he won't drop his divorce case. Then maybe he'll try to take my baby, right? She can't let him know that. She can't let him know that because he's packed her up, ready to go. It's manipulation. And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew the jig is up. He might seek more control. It probably just went in there. But Stephanie Murphy told you that when they went, and she was trying to get an injunction, and it was denied. And he was trying to get custody, visitation, see his baby for the first time. She said something I thought was very telling. The judge gave Doug sole medical control, or primary medical control over the baby, right? So now he's already got some control. She can't do anything without him on the medical stuff, right? Of course she's worried. Of course, because she wants that baby, and she'll do whatever she can do to keep it, her. And I wouldn't put anything in the fact that she didn't confess on her phone, that she didn't tell somebody that she had shot him one way or the other. She didn't even tell her mama. Her mother would have you believe that in all these years, she's never said something to you. You think she's going to put it on her phone? No, she's smarter than that. If that's true, she's certainly not going to put it on her phone. And just because you search up how to co-parent with an abuser doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. And she's trying to manipulate you. You can decide what you think about her testimony. She's a witness like any other. But I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry, have to take breaks, and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's tissues. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes. Didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. And reasonable doubt, I would ask you to read your instructions because that board they put up was an incomplete instruction. It left out parts. And the part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the 2nd degree with a firearm. Thank you. Thank you, Judge.
All right, can you go back to your instructions? And if you remember, we left off at 3.10. And we're going to ask when you find that, if you just look up at me and I'll know we're all on the same page.
Okay, so they're deliberating now for an hour so far. So what are y'all thinking? What are we thinking? How are we feeling? Let's do a poll. I'm going to read some documents to y'all. Start a poll. What? Oops. What? We'll do a couple of them. We'll do how long, but in a minute, how long you think it'll take. But first, let's do, what do you think the verdict will be? Guilty? Not guilty? Hung jury. What, if anything, will the jury say? So here's what I'm thinking. I think that, well, first of all, I could never be on this jury. I could never be on this jury. I've been in domestic violence situations. I couldn't, they would not choose me, and for good reason. I would not be able to be impartial in this. I can't. I wouldn't be able to do it. But I think that looking at the evidence, the strongest thing and I said this earlier for anybody who was in here, I put it in the comments, but I think that the strongest thing that the prosecution has going for them is the timeline. And I think that the strongest thing that the defense has going for them is the history of aggression and abuse from Doug. And I get that she's saying he had never hit her before or whatever. I get that. But that's not, like, that's not what it is. That's not, it goes far beyond that. Like, abuse is not just punching people. I want to take a look at a couple things real quick. Couple things. I have like a loose, this is not a complete timeline, but just to kind of give a little bit of an idea. Because the timeline is one of the things that I think is one of the things that they brought up in the closing arguments, that they hadn't lived together in 3 years. Just means nothing without eyebrows. The note on the tablet from the ex-wife swung me. Yeah. Mental abuse is equally horrific. I agree. Doug did in a deposition. I'll show y'all that in a minute. Hello. Y'all, I have a birthday dinner to go to at 6, so I can't do verdict eyebrows tonight. I'm an evidence doc person too. That's my jam. All right, so let's take a look at some of this real quick. The timeline. So Renee passed away in 2015. In August 25th, Doug met Ashley. 6 days later, they said, "I love you" for the first time in texts. They got married without telling Evo or the family on September 8th, just 13 days after meeting. He did his vasectomy reversal in April, and then in August, they found out that she's pregnant. And then later that month, right after she got pregnant, she moves back to Florida with her mom. So the time that they lived together and were together, married and actually living together and all of that, was very short. So she went back to get her stuff. So then Doug gets, he goes to get the, I can't talk. He goes to find an apartment nearby, and then Ashley ended up leaving to go back to Charleston. Now remember, they have a couple different reconciliations, and some of them I couldn't find the exact dates, but they have a couple different short reconciliations here and there. Oh, the note. Okay, let's talk about the note real quick. Let me pull up the note. Here's the note. All right. So it is dated September 18th of I'm seeing congratulations. What are we congratulating on? What did we miss? Hold on. What did I miss? Oh, you're promoted. Happy promotion. Congratulations. I saw everybody was saying congratulations, and I like congratulations stuff. I like to be able to celebrate y'all, so I had to go back and see. All right. So this is dated September 18th, 2017. Doug, I can honestly tell you that I am completely heartbroken. Please do not be rash. Hear me out and read all the way to the end of this letter. Over this past year, we have had good times, yes, but you have also displayed scary and irrational behavior with sudden bursts of rage and fits of anger, extreme and uncontrollable anger. This has left me constantly stressed to the point of nausea and scared for my safety. I never know what will set you off, and so I always walk on eggshells and try to keep the peace. Something about the eggshells thing, when you hear that a lot from people in either violent or emotional, abusive relationships, like coercive control relationships and stuff like that. The whole walking on eggshells thing is a form of control. If you constantly are having to watch every move you're making, it's a way for them to control you. If they're controlling your behavior by keeping you worried about what's going to happen if you don't behave a certain way. Always worried about the next thing that's going to happen. And they talked about that on that wheel too. So always walking on eggshells, trying to keep the peace. It's like you are two very different people, and I am never sure when you will lash out and be overtaken with rage. You yell, scream, and cuss at me, even telling me we should get a divorce, that you don't want to see me or touch me again, and that you don't love me. You have put my life in danger multiple times when you had a sudden fit of anger when driving with me in the car. You have driven erratically, way too fast, broken traffic laws, crossed in front of oncoming traffic, driven up over a curb, through grass, almost hit several trees, and acted like you were going to crash the car. Sometimes you break things, smash drinking glasses on the counter, in the sink, or even in your hands because you were so full of uncontrollable anger. You have thrown and broken things, chairs, cups, books, anything you can get your hands on, even a loaded gun which left a giant hole in the wall in the kitchen. You have even pointed a loaded gun at your head and then shot a hole in the ceiling in the kitchen. There are holes that you have punched in walls all over the house, and even a door from when you got angry and you were yelling in a fit of rage. You are very scary and threatening. You use very scary and threatening language that makes me fearful of you and what you might do to me. You even say things to make it sound like I am lucky you punch walls instead of me because you don't know what I have done or what I am capable of. You have intimidated me by getting in my face, even cornering me in either the closet or bathroom and blocking my way out. You have even grabbed my arm and squeezed and yanked me. I have even seen you get mad at the girls, yelled, screamed, and cussed at them. I now understand why Eva used to tell me she was afraid of you. You are possessive, controlling, and manipulating. All of this is not even to mention the conditions I have been living in since moving in with you the beginning of last November. The house has not had heat or AC since before I moved in, but you made it sound like it was about to be fixed. The house is falling apart in many ways, cracked the floors in the bathroom that pinch your feet when you walk, toilets that don't work all the time, and places where the ceiling is literally falling down in giant chunks. There are exposed outlets and wires where I have electrocuted myself. There is black mold on the walls and ceiling in the kitchen pantry. The sink in the master bathroom was broken for months, so I had no hot water all winter. The electric and water have been turned off because of unpaid bills. We even get a notice in the mail that our house was going into foreclosure. We did not have a working dishwasher for months. The tap water is unsafe to drink and smells and tastes like chemicals, and we know it killed our fish. The water filter broke in the refrigerator, and we have been left without safe drinking water or ice, forcing us to buy bottled water. We have run out multiple times now and been without water for days, even over a week. This has been going on for months. The freezer does not work and leaks all over the wood floor in the kitchen, which now is molding, rotted, and caving in. All of these things and more I have overlooked and lived with for now a year because I love you. But even since finding out I was pregnant, you have continued to display psychotic, irrational, and unsafe behavior that has left me fearful for my life and safety, as well as that of my unborn child. I have come to get only what belongs to me. Do not harass or try to follow me, or I will call the police and have a restraining order against you. I will talk with you only via text starting Tuesday, September 19th. Do not call me or my mom. We will not pick up. Thank you for understanding, Ashley. So that is the letter that they talked about. So let's see. Their business closed right after that. There was a hearing about the restraining order later that year in November. The following year, March 15th, Doug sent that letter. This is what they talked about in trial. The letter is, they said that she left the letter for him when she went to go get her stuff. After she moved back in with her mom, she went back to get her stuff and she left that letter for Doug when she went to get her stuff. Okay, so let's see. She checked into the hospital 3 weeks before the due date, claims that she was being poisoned. The poisoning thing, they did all kinds of tests on that. She was not being poisoned. There was no kind of, the chemical testing that they did through the police department and through the hospital, both came back negative. But she had the C-section to deliver the baby. Doug was unaware of the birth. That was March 19th of 2018. The following month, she filed an injunction to deny Doug custody or visitation, saying that he violated the South Carolina injunction. There was a hearing in July for the injunction for protection for domestic violence. The judge denied the motion in September and set up visitation schedule for Doug and Ashley. So in August, that's when she showed up wearing the ring that she said was not an engagement ring, but I guess in court documents and stuff it says that it was an engagement ring. But she said on the stand it wasn't, that she just likes rings or whatever she said. So at that time, when she was wearing the ring, when she showed up to drop Emerson off, Doug hired a private investigator who found out that she's seeing someone else. So Doug filed for divorce. Ashley then accused him of physically and sexually abusing their daughter. CPS found no evidence of abuse. Ashley also claims Doug poisoned his first wife, Renee. She died of a heart condition. They reconciled again. I don't have the dates on that one. There was a reconciliation at some point during that time, and then they split again later in the year. And then December 6th, there was a police report filed where she said that there was that he admitted to putting a tracking device on her car. I have that text too. We'll look at that in a second. And had said that he had followed, and she said that he had followed her before, that she saw him tailing her before or whatever. And she wanted it documented. Okay, so spring of 2020, Ashley tells Doug that she's moving to Maryland with their child and her mom. So he finds a job in Maryland and rents an apartment nearby. So they are planning. So the whole plan was that he was going to move to Maryland too, so that he could be near them, but they were going to have separate houses. during the summer, they suddenly had some kind of reconciliation again. Of course, it didn't last. Doug packed the U-Haul to move to Maryland. So this is the day that he was killed. He brought the U-Haul. He drove the U-Haul over there. They were packing the U-Haul, and that's when she shot him, and he died an hour later. An hour after the 911 call, he died at the hospital. And then Ashley was arrested in November. Okay, so let's look at this real quick, because I feel like it was kind of the timeline and the way that they go over things is kind of all over the place on this. Oops. But let's look at let's do this one first. Oops, too much, Brandi, too much. Trying to keep the verdict clock so y'all can see it. Okay, so this is the petition for injunction for protection against domestic violence. Okay, so the petition. Lucy's snoring. She's snoring. Okay, so petitioner is either a victim of domestic violence or has reasonable cause to believe he or she is in imminent danger of becoming a victim of domestic violence because the respondent has, and then these are the ones that she checked, committed or threatened to commit domestic violence, which includes any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another. With the exception of persons who are the parents of a child in common, the family or household members must be currently residing or have in the past resided together in the single same dwelling unit. Also checked previously threatened, harassed, stalked, or physically abused, attempted to harm the petitioner or family members or individuals closely associated with the petitioner, intentionally injured or killed a family pet, used or has threatened to use against the petitioner any weapons such as guns or knives, physically restrained the petitioner from leaving the home or calling law enforcement, a criminal history involving violence or the threat of violence, another order of protection issued against him or her previously from another jurisdiction, destroyed personal property including but not limited to telephones or other communication equipment, clothing or other items belonging to the petitioner, engaged in any other behavior or conduct that leads the petitioner to have reasonable cause to believe that he or she is in imminent danger of becoming the victim of domestic violence. So it says on the evening of December 27th, December 2nd, 2017, I received a package in the mail. So this is that package that she was talking about. I received a package in the mail that I was able to identify as being sent by Doug because I was able to recognize his handwriting on the front, and the name of sender was Doug, and our South Carolina home address was listed as the return address. The package contained several items, including a handwritten note from Doug wishing me a happy birthday, as well as 4 teacups and matching plates, a tea maker, and what appeared to be several bags of tea from Tivana or something. When I opened the box, there was a strong chemical odor which made both me and my mom feel very sick. I was living with my mom at the time, and she was with me when I opened up the package. Because of my history with Doug and his previously threatening statements, I took the package and all its contents to the Manatee County Sheriff's Office, where hazmat was called to the scene. Upon testing, it was determined by hazmat that the T from Tivana had been removed and replaced with potpourri. The potpourri was found to contain a hazardous, I can't say urea, a hazardous substance normally found in fertilizers used in the agricultural industry. It is also used in the medical industry to induce second trimester abortions in pregnant women by burning the fetus to ensure death before delivery. I was in my second trimester, approximately 5 months pregnant at the time when I received this package from Doug. On or about October 27th, 2017, Doug and I were having an argument via text where Doug admitted to several acts of violence, including when he pulled a gun on me and shot it in our home, as well as punching holes in the walls and punching our family dog, Sully. On or about September 10th, 2017, Doug and I were having a verbal dispute over the telephone where Doug was very angry and aggressive. After our call, Doug drove from South Carolina to my mom's home in Florida, where I was staying at that time. Soon after his arrival, Doug had a violent outburst, yelling, screaming, cussing, and when I refused to go to bed with him, he began to throw things. I then ran to the bathroom where I was so afraid I became violently ill, and he followed me into the bathroom and continued to harass and scare me, standing over me. Doug left Florida that next day to return to South Carolina, and on more than one occasion, he threatened to use force to bring me back to South Carolina by forcing me to take medication to keep me sedated if he had to, and said I would have to take the medications whether I liked it or not. Doug had, on previous occasions, forced me to take medications I did not need or that had been prescribed for other people. On or about August 4th, 2017, Doug trapped me in our master bathroom and forcefully grabbed me and held me down when I tried to escape. On or about June 20th, 2017, Doug punched our family dog, Sully, so hard in the face that he was rendered unconscious. On or about June 17th, Doug and I were at a public beach when he became angry and aggressive. He shoved me, yelled and screamed at me, and threatened to leave me at the beach to walk home, which was about 7 miles away. On or about June 15th, 2017, Doug pulled a loaded gun on me. He then threw the gun at me, but missed me. The gun hit the wall instead, punching a large hole in the wall. Doug then grabbed the gun again and held it to his own head, threatening to kill himself. He pulled the trigger, and though he missed, he shot a hole in the kitchen ceiling. On or about June 1st of 2017, Doug kicked our family dog, Sully, causing Sully to go flying backwards and yelp really loud in pain. Oh gosh, that hurts my stomach just hearing that. This hurts my stomach hearing that. This caused Sully to cower and be very afraid of Doug. I just want to hug Lucy right now. On or about April 2017, Doug threw our family cat off the kitchen counter, causing her to hit the ground hard. She screamed and was in fear of Doug as he has thrown her on other occasions too. April 14, 2017, Doug trapped me in the master bedroom and prevented me from escaping. Doug threw a punch and his fist went all the way through the wall, causing drywall to fly off and hit me in the face. In addition to the above described incidents, Doug made several threats to me, including statements like, "If I can't have you, no one can," and telling me that he could make people disappear. Doug also claimed that he has killed and poisoned people and that he got away with it and that he could do it again. Doug also stated that he had trackers on all the cars and that he had video surveillance in our home and that he could see on his phone anytime a door or window was opened. Because of his threats as well as history of abusing both me and our family pets, and his uncontrollable anger and unstable behavior, including the use of deadly weapons, as well as self-harm threats, I fear he will seriously harm, injure, or kill the baby. Okay, so That's that one. All right, so let's go through the motion to dismiss because this one has a lot of the evidence stuff in there that you can see. So all right, so this is the defense's motion to dismiss. All right, so after meeting in 2016, whirlwind romance, et cetera, et cetera. 30 years her senior, Mr. Benefield portrayed himself as everything that she was waiting for her entire life. In reality, his presentation was a complete fraud. On the day of the homicide, September 27, 2020, Miss Benefield knew the following about her then husband. He had fired a handgun into the ceiling of their kitchen in an effort to intimidate her. He threw a loaded gun at her. He punched their dog in the face hard enough to render the canine unconscious. He regularly carried a loaded, concealed firearm. He unlawfully placed a tracker on her car, and she frequently observed him tailing her car. He was caught by a neighbor at night standing in her backyard and peering into Miss Benefield's home. And we have the deposition of that too, so we'll take a look at that, or the transcript. Let's see. He punched numerous holes in the wall of their home. His previous marriage had a history of domestic violence. Okay, so following Miss Benefield's initial departure from the marital home in Charleston, on August 28, 2017, she returned to gather her belongings and moved into a home owned by her mother in Manatee County, where the homicides took place. It is not difficult, given the history detailed above, to appreciate and understand why Miss Benefield feared her husband. While physical conditioning played a large role in Miss Benefield's career as a ballerina, she was no match for Douglas Benefield. In sharp contrast to Miss Benefield's lithe structure, Mr. Benefield was a former naval officer, admittedly skilled in hand-to-hand combat, who stood 5'9", weighed 169, and was in prime shape. So here's the pictures of him in prime shape. This is him showing how these were the ones that they were talking about in court too. They didn't really, we didn't really see them, but those are the ones that they were showing. Okay, so during their relationship, the deceased frequently represented to Miss Benefield that he worked for the government agencies, or for government agencies such as CIA, was a technical expert in advanced classified fields that required a security clearance, and trained with both active and retired special forces in hand-to-hand and close quarters combat at a secret location in the United States called the Ranch. I want to know so much about the Ranch. Moody and unpredictable, he would all too frequently let me see if I can do this. See if I can do this without trying to look at it so I can put it on this screen instead of that one. Okay, there we go. That's a little bit better. Okay, there we go. All right, moody and unpredictable. He would all too frequently vacillate between calm. Hold on. If I do it one more time, it should be big enough for me to read right here. There we go. Perfect. Okay. Between calm and rage, Miss Benefield never knowing what would set him off. He would often tell Miss Benefield, "You haven't seen the warrior side of me and never want to." September 27, 2020, the deceased arrived at Miss Benefield's residence driving a U-Haul truck at approximately 5:30. Miss Benefield resided at, that's the address, with their minor daughter and mother. In the weeks preceding the incident, Miss Benefield, her mother, and daughter were preparing to move to Maryland. Mr. Benefield had taken a temporary local apartment, and he too was moving to Maryland, although it was made clear to him and he understood that the parties would not be cohabitating upon their arrival at the new destination. Material facts. As the decedent arrived, Miss Byers and the minor child were leaving the residence to walk to the neighborhood splash park. A brief acknowledgement between them and the decedent took place. Miss Benefield was in the garage packing items into the boxes. So this gets into, he was a little bit unclear, I think, and maybe it was just to me because the way he talks is kind of hard to follow him sometimes, but this is him describing what he says happened while they were there. Okay, so while Miss Benefield was in the garage packing items into boxes. After greeting one another, they engaged in a brief discussion about the pre-staged furniture and boxes in the garage that were ready to be loaded into the U-Haul. While the decedent began moving the pre-staged furniture and boxes into the U-Haul, Ashley started packing items that were in the rear of the garage in the shelf area. Doug's mood was consistent with his prior history, happy, hyper, and animated, arms and legs flailing one moment, and then agitated, sullen, and intimidating the next, annoyed that they had not already moved, with fixed, intense stares at Ashley. A discussion ensued about the order the furniture should be loaded to facilitate Ashley's belongings being unloaded first, since they would be residing in different locations upon arrival in Maryland. This annoyed Doug, and the camera just moved. Didn't it? Did I imagine that? I'm pretty sure it just moved. Okay, so a discussion ensued about the order of furniture should be loaded. So since they would be in different residences upon arrival in Maryland, this annoyed the decedent, and he expressed frustration and anger by stating, "It should not be a your house, my house arrangement. We are moving together as a family, making a fresh start, but you're dividing us." Things began to escalate immediately thereafter. Doug exclaimed that it is time that Ashley began acting like a wife. Otherwise, he would have to pack her in the pod. In short, a non-survivable transportation unit that Ashley clearly took as a threat in retaliation for her lack of submission. It was a refrain that Doug had echoed before on several occasions, where he would remark, "If you do not cooperate, I will ship you in the pod, and you won't like it because it will be hot and slow. If you're going to be difficult, you're going to go the slow way to Maryland." Expressing that he then needed to make room in the pod, Doug was not dissuaded by Ashley telling him that the pod was full, packed to the brim. Instead, he attempted to gain access to the pod, but found it locked. He demanded the key, insisting that he needed to make room in the pod. Miss Benefield denied having the key or knowing where her mother put it. Doug continued to insist that Miss Benefield unlock the pod. Okay, so Ashley's inability to provide Doug with the key angered him. He confronted Ashley, and then he moved in close, crossed his arms, and glared at her, concluding that she was defiant. He grew tense, and his shoulders raised, fists clenched, heavy breathing, and sharp staccato derisive comments spewed forth. As in South Carolina, Ashley was concerned for her safety and wanted to avoid antagonizing Doug. So Ashley attempted to de-escalate the situation by redirecting the conversation and calm him by speaking softly and positively. He would have none of it, and in an effort to protect herself, Ashley moved away from him to the rear of the garage and resumed packing. Her efforts having been rejected, Doug responded by growing increasingly aggressive and threatening. He began to hover over the top of Ashley in an intimidating manner while she was bent over, packing boxes in the garage, fists clenched, arms jiggling as if getting ready for physical contact. Miss Benefield feared that he was going to lash out. In an effort to extract herself from the situation, She attempted to persuade Doug to leave by remarking very gently that she was exhausted and was finished for the day. It fell on deaf ears. Doug acknowledged her comment but kept packing and loading. Afraid to command him to leave, in another effort to put even more distance between them, Ashley left the garage and entered the house, where she continued to pack boxes and move them into the garage. While walking through the living room, the deceased body checked Ashley, approaching Miss Benefield from the kitchen area instead of going around her. The decedent's shoulder, chest, arm made contact. This is what he was talking about, the body check where they had the scratches. Anxious but nonetheless caught off guard, the contact was sufficient to cause her to lose her footing, stumble, almost fall. She could not help but notice Doug was mumbling under his breath and clearly hostile. Scared, she realized the pattern of contentious behavior toward her was escalating quickly. Again, thought I saw something moving. Again, while in the garage, emphatically claiming that she was done for the day and wanted to continue the following day, Doug, while facing the laundry room, and Ashley, while facing the opening of the garage, made physical contact. So another body check. She was sure that both times were intentional. Once again, trying to stop any escalation, she apologized. Finally, while Ashley was entering the house from the garage and he was heading into the garage from the residence, the two met in the hall. He was holding a medium-sized assembled cardboard box. She stepped to the right and he deliberately drove the box into her in an upward motion, resulting in considerable pain and scratches to her right side. Those are the scratches. Ignoring her entreaties to finish, like, okay, last chair, last table, etc., in a final effort to rationalize ending the day's activity, she entered their child's bedroom to show that there was very little left to pack and move. Standing in the doorway to the child's room, he blocked her exit while puffing his chest, clenching his fist, and glaring at her. Frightened, she backed up further into the room and put some distance between them. Coming back in. But sensed an attack was imminent. So he knew what he was doing and accused her of trying to force him to leave, get rid of him, and that he was not leaving. He could stay if he wanted to, spend the night if he wanted to, because he was her husband. So this is showing that. So this is the part. So that's what led up to it. I think they went over pretty clearly about the whole grabbing the gun and all of that, but I think that it was kind of unclear about I know some of y'all were saying that he was being unclear about what kind of led up to it and what was happening, what was going on while they were there. Okay, so that's the, yeah, that's the, I'm done, you need to leave now, etc., etc. Okay, let me get down to, yeah, there's, I've got this kind of pulled to the bottom so we can see it when they come back on to tell us what the question is. Oh, this is the part where they're saying about the legs going up. She did not, still he did not stop coming toward her. This one she was shooting, and he said that the legs flew up in the air as if his feet slipped out and he fell backwards. All right, let me pull. So here's the depositions.
All right, welcome back. You're back on the record in State versus Benefield, 2020 CF
3014. And you've been called back because there's a jury question.
Jury question.
And I'm going to read the question, and if either side wants to approach and look at it yourselves, you sure can. I'm going to read it as it is. Dr. Quintella testimony. Defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine? Anybody want to be heard first?
Any particular order?
No, sir.
I understand the question. What's the court's inquiry?
How do you, I'm listening for, I mean, I know in my mind how I think I'm going to respond, but I'm always going to give the parties an opportunity to be heard on
Sure. I think they should have Dr. Quintell's testimony read back to them. Specifically because I asked Dr. Quintell if he reached any conclusions as a result of meeting and evaluating Douglas Benefield. And those were the conclusions that Dr. Quintell said he reached. It had nothing to do with my asking him if it was based upon anything Ashley Benefield told him. And I think unless that message is sent, unless that's clear to them, then I think it's a terrible prejudice to the defense.
I'm sorry, what's the prejudice to the defense?
What's the question?
No, what was the prejudice to the defense? If what happened?
Prejudice to the defense is that they're being misled.
If we do what?
If we do not read back their testimony, read back his testimony. That way it doesn't have to be the lawyer's comments, it's the testimony of the witness, it's objective.
Judge, I think there are a couple options. One is the standard use your memory. I don't know if the court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
All right, any final thoughts? Well, they clearly are not asking for a read back. They're asking a factual question. And I would direct both sides to standard jury instructions 4.3 and 4.4. 4.3 addresses answers to juror inquiries during deliberations. 4.4 is requests for readback or playback or transcript of testimony. We've all done this long enough. This is not a request for a readback. If they want to read back, they say we want to read back. They ask for testimony. It happens all the time. So at this point, the appropriate response is going to come from 4.3.
What kind of name? Wonderful. Wow. Judge, my concern, Your Honor, is that we're just assuming they know that they can ask for a readback. And I don't know that that's a fair assumption.
In your 400 trials, when has a judge ever given an instruction, hey, by the way, you could ask for a readback?
No.
No, I haven't either.
No, but I don't know if they know that, and the question may be inarticulate, that maybe you could ask for a clarification of the question.
Your Honor, Judge, we don't object to 4.3. We ask that you.
Yeah, this is live.
Right?
We agree 4.3 is the right.
Yeah, that's the
Thank
correct
you.
response.
Yeah, if you needed us to agree, we do.
Okay. No, it's not even a debate. That's the correct response. Is 4.3.
Aggressive typing. This is some per my last email typing. Thank you, Anne. Thank you, thank you. Especially the enter. Per my last email. They're asking, did Dr. Cantrell base his opinion on what he observed or what Ashley said? Here, I'll put it on a thing. Hey, Kathy.
Okay, I'm going to read you what I plan on telling them, and then you can comment on it how you want. This comes directly from 4.3. Members of the jury, I have discussed your note with the attorneys. You have asked the following question, and then I'll read it. If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it.
No objection.
Object.
Object for the same reasons that you want me to affirmatively offer a readback.
Yeah,
Okay.
just so we're clear, I think that what created that question was the plethora of misrepresentations that the state delivered to them in their closing argument, and that's the reason why they've asked that question.
You know what? Tell me his name. It's not Quintella.
Quintal.
Quintel.
Q-U-I-N.
Like William Tell, Quintel.
Okay, thank you.
Hey, pretty girl.
Because like a quinella is a bet at the track, isn't it?
I think so.
I think that's what they're.
Daily double.
It's like me trying to call the other witness the wrong name the whole time.
Keyless.
Hi. Hi. Oh, goodness, bless you.
Madam Clerk,
Bless
I'm
you.
going to have to send this to you.
Big sneezes. Big
Because I don't have
sneezes.
a printer.
And thank you for gifting a membership.
Yeah, I'm sure.
Hi. Hi, my love. Hi, my love. Who's the best girl?
Yeah,
Lucy just says, free Sully. Free Sully.
All right, ready to bring the jury in?
Bring the jury.
Yes, Judge. No, he was back.
I wonder how late they're going to let them go today. You're a good girl. Yes, this is live. What is it? What is it?
Do you guys want me to broach the subject of food as well?
Yes. Yes.
Food. Oh, so they're keeping them.
Up to you, Judge.
Okay.
I have a birthday dinner I have to go to in an hour, so we will have to adjourn. Unfortunately, if they're not done.
And y'all can have a seat wherever you want. You don't have to sit anywhere particular. All right, y'all can have a seat. Welcome back. Members of the jury, I have discussed your note with the attorneys. You have asked the following question. 7/29/24, Dr. Quintella testimony, defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine, signed one of the jurors? If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. Also, I don't want to know what's been discussed. However, it's getting to be almost 6 o'clock. If you want us to order food, it is not, it's not steak and lobster. But we can order some pizzas and get some sodas and have them and brought to the room. If you want that to happen, also send a note through the deputies. All right, you may retire to continue your deliberations.
Yeah, this is the first question so far, Kathy.
All right, you can have a seat. The jury is out.
Pizza sounds good. I have to go to some fancy schmancy dinner tonight. See if they're going to say anything else, and then I'll keep showing y'all the other stuff. Can they get beer and wine? Could you imagine jurors deliberating over cocktails?
I missed the last thing you said.
Oh, yeah.
Okay. Well. All right. Well, I guess that's it. Okay, so we can read a little bit more of this, and then I'll show y'all some of the notes and stuff that, some of the deposition stuff. Okay, so this is from the deposition of Doug. So it doesn't give the whole thing on this. This is just the pages that are in the motion to dismiss, but this is where he admits to doing a couple of the different things. So, okay, so he's asked about the gun. He says, after a few, maybe another minute or 2 minutes, I couldn't tell you the exact time, of Ashley talking about Eva. And he says, of Ashley talking, and I am begging her to stop talking and to please stop. And your head's on the counter. So he's explaining what happened. So he says that his head's on the counter, and Ashley won't stop talking about Eva, and he's begging her to stop talking. She wouldn't stop. She just completely would not stop. And so out of complete and utter frustration, no anger whatsoever, I don't remember feeling a single iota of anger. It was purely utter frustration. The gun's sitting in front of me, and I pull it out of the sleeve and I shot at the ceiling. Did you say anything before you did it? And he said, I said nothing except for I was, up to that point, asking her to please stop talking and give it a rest. Okay, so then this is a separate page. Let's see. Somebody did do something stupid, which was... okay, so did she somehow, that starts like mid-sentence. Did she somehow egg you on with the gun at any point in time? And I didn't hear anything about that. He said, she egged me on in the argument, not stopping. She didn't bring the gun into the house. This is the questioner. She didn't bring the gun into the house. You did, right? And he said, no. And then the person asks, you were the one that threw the gun against the wall, correct? He said, absolutely, and I admitted to that. Then he was asked, you were the one who pulled the gun out of the sleeve and discharged it? He said, absolutely, and I admitted it. But And then he's asked, but you think it was her fault? And he said, absolutely. There's two parties. She had the ability to stop arguing, and she should have stopped when you told her to, correct? And he said, any one of the 100 times I asked her to. So I just have such mixed feelings about that, because you can't, like, it's not, that's just hard, because it, like, if, you know, if she's constantly going, that can be triggering, but that can be triggering for like yelling or like saying stuff or whatever. But I don't know, but like throwing a gun and shooting a gun at the wall, like that's not, you can't blame that on, I don't know. I have like, if I get to that point, like I think the best solution is to leave, you know, remove yourself from the situation. But I guess he says it's her fault. I'm telling y'all, I think they're both toxic. I think they're both toxic. And that's why this is, I've gone back and forth on this one so much. So anyway, all right. So that's one page. All right. So here's another one. Oh, this is just talking about, this was, this part's just, he's showing, I guess, a picture or something of where they were sitting when this was happening. And they asked, when you threw the gun, the effort was to make her shut up. And he said, no, that's not what was going on in my head. My head was pure expression of frustration. And then he was asked, do you see where it says right here in your own document, that's now part of Exhibit 3, I threw it to make her shut up. Do you see you wrote that? He said, yes. This is your writing, yes. And then he's asked, when you shot, it was to make her stop fussing again. He says, I'd say that was the result, but I wouldn't say that thinking back. And then he's asked, I'm asking what you said here. I picked it up and I just shot it to make her stop fussing. And he said, yeah, that's what I said there. And he said that he wrote that at the beginning of the injunction case when he started putting all of the stuff together for it. They asked if he has an anger problem, and he said, no, absolutely not. Have you ever attended anger classes? And he said, I have never had an anger issue to attend an anger class. Sorry. Sorry. Family stuff. Okay. I lost my place. Have you ever attended an anger class? I've never had an anger issue to attend an anger class. So Sully is the dog. So they ask, you hit Sully that day? And he said, Sully is protective. He was under the table. Get to the rest of this part. That's the same. My question is, did you hit Sully, not why? And he said, you could call it a hit. Yeah, you could call it hit, yes. He sprung up into it. I guess your lap. Wait. You could call it hit, yes. And then the questioner asked, you called it hit. And he said, yeah. And they asked him, he sprung up into it. I guess your lap. And I reacted and hit him. He said, yeah. So, oops. So when you say you could call it hit, you called it hit, correct? And he said, yes. For lack of better words, yes. The dog sprung up on my lap all instantaneously, trying to crawl on my lap, sharp claws, and I've got shorts on. And he said he doesn't remember exactly how he hit him. He said, this is, again, our dog is like, you know, family, and I just wanted everything to stop, and I wanted him to stop, and he wouldn't. He would not stay under the table, and he kept... And the questioner said, he wouldn't stop either, so you hit him, correct? And he said, yes, I hit my dog. So he shot the gun because it was Ashley's fault. He punched the dog, or hit the dog because it was the dog's fault. This is the incident report. Where she called to report the tracker and feeling like she was being followed. So it says, I met with Ashley in True and received a summary of the incident. Okay, so Ashley is documenting the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. Ashley has observed her husband driving behind her vehicle on multiple occasions in the past, which concerns her. Ashley wanted this information documented due to the couple's long history of disturbances and child custody incidences. According to Ashley, she brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact that a tracking device was never observed on the vehicle, an information report was completed. Ashley was also advised that she could add information to the report at any time. So here's some of these texts. So, this one, I know that this is hard to read. So this is him messaging her. I have to lean over to see it because I can't read it. It just starts like in the middle of a sentence. It says, married, we moved too quickly, both pretending everything was okay. It says, I will promise you going forward, I won't do anything stupid, embarrassing, or insulting like I did with Waterworks or back early in the year when I put Eva's tracker on your car. And I ask you to let's deal with these murder and poisoning accusations. So this is the text where he said that he put the tracker on her car. He put Eva's tracker on her car. And he's asking her to deal with the murder and poisoning allegations because this is when she was saying that he was poisoning her and that he believed that she believed that he had poisoned and murdered his second wife, Eva's mom. If you want another autopsy, then we will do that. I'm okay with that. Whatever you need to do over the next year to fix something and this broken something, you can tell me and we will do it. The fundamental thing for me is I believe in you, even in the middle of all the accusations, regardless of how they started. I know in my heart you are not only a good and godly woman, you are an extremely intelligent human. I tell everyone that I believe you are a genius. I simply believe in you. You said one day you shut down being together that I had, and then it just cuts off. Okay, next exhibit. Okay, so this is where the person who was the neighbor who said that they saw somebody in the dark. Remember, they were talking about that, and the defense is saying that it was Doug, and the prosecution is saying that they don't know who it was. This is from that. So they're asking about the neighbor seeing the person out there. So you said it was dark out, correct? And he had a baseball cap on. They ask you had at the time a general description of him, his approximate height and weight, but you didn't feel comfortable being able to identify a picture. Is that correct? And the neighbor said, absolutely, I could not. It was dark. So while this had occurred, on the heels of it having occurred, did there come a time where an audio recording was played for you? The neighbor said yes. Of a particular gentleman's voice? The neighbor said yes. And did that voice sound familiar? The neighbor said yes. When had you heard that voice before? And the neighbor said, when I asked who was in my yard. And they asked, when you asked this gentleman that you did not give permission for who was trespassing in your yard, what he was doing there. It's correct. So they're saying that the neighbor said that when the recording of Doug's voice was played, that it was the same voice of the person who she told to get out of the yard. So it says, when the audio was played, you recognized the voice as one and the same. And they said yes. And at the time you were certain of it, yes. And now that individual turned out, to your knowledge, to be Douglas Benefield, did it not? And they said correct. Do you remember disputing with him his statement that he lived there, that you were familiar enough with where he pointed to the neighbors in that immediate area that you knew it wasn't the case, and that was what made you alarmed and led to the call to call the sheriff's office? Does that jog your memory at all? So this is where they're describing exactly where they saw them. It was in the backyard, and it's saying that he was in the backyard and he was right there. So they were showing on a thing where it was. The judge just walked back through. There's a pond there. There's bushes, oak trees, etc. It's really creepy at night. The only reason I saw him was because of the moonlight, because I have 2 huge oak trees in the back. But yet he was here, he would have looked like straight onto Ashley and Alicia's. You could see their garage. So that was what the neighbor said. All right, so this is another one. This is about the hole in the wall. So I wasn't sure you told me when you hit the hole in the wall. Was it before or after June 15th? Ashley's saying April 14th, so it would be before that, correct? Correct. And you admit that that happened on or about that day, that you hit the wall to get her to stop talking. So again, it's to get her to stop talking. He said, I hit it out of frustration. It had the effect of stopping her for a minute. And they asked, what were you frustrated about? And he said the same thing. Ashley, the story is nothing specifically like she said. I was the one in the closet, and she was standing outside of the closet, and we were arguing once again about Eva. So remember where Ashley said that she was trapped in the closet and he was standing outside of the closet and he wouldn't let her out and he punched the wall? He's saying that it's the opposite, that he was inside the closet getting dressed and she was standing outside of the closet by the bed, and that's when he punched the wall. We were arguing once again about Eva. It seems like not all, but a large portion of their argument seemed to be about Eva. Why were you in the closet? He says, I was changing clothes. You were arguing about Eva, and did you hit the wall in the closet or someplace else? He said, no, I was in the closet, and Ashley was standing at the foot of the bed, which is 10, 15 feet away. And they said, okay, I'm sorry, you hit the wall outside of the closet, but Ashley was 10 or 15 feet away. Is that what you said? He said, no, I was in the closet, sort of in the doorway. And the same exact scenario, she would not stop fussing about Eva. See, it's the same exact scenario, she would not stop fussing about Eva. So you hit the wall where? And he said, I was inside the closet and hit it from on the inside of closet, just about where there's an ADT alarm system. It put a hole in the wall. And then it went through, my fist went through the sheetrock and sort of hit the outside. I remember that because that's where I first started to have them put the ADT. So they had already started cutting a hole. And he said it did get repaired. Is this Ashley's fault again because she wouldn't stop? He said, I would say Ashley was the cause of the argument. Yes. Was Ashley the cause of your putting your fist through the sheetrock? He said, no, it was my bad decision, but Ashley caused the argument. Ashley was the entire cause of the argument. And they said, so Ashley was not the cause for you putting your fist through the sheetrock, but she was the cause for you shooting the bullet in the ceiling. And he said, Ashley was the cause of both arguments because she would not stop arguing about my daughter. He said, both were my honest, bad decisions in a stressful situation. Let's see. Okay, so during your arguments, okay, so the question is not about the trajectory. Okay, so my question is, did she ask you to come to Florida when you came to Florida in September, or did you come on your own? He said, no, I came on my own because she was not answering the phone very much. During your arguments in the past, besides shooting a firearm, throwing a firearm, and punching a hole in the wall, did you ever throw things besides the gun? And he said, I don't ever remember throwing anything. No, I don't remember. The only thing I remember, one time standing at the sink, and there's a glass in the sink, and it broke when I put it down too hard. Other than that, I've never thrown anything. So you were in an argument, and you put a glass down too hard, and it broke. Is that what you're saying? And he said, yeah. When was that? He said, I don't remember specifically. So he says that he put the glass down too hard and that's how it broke. She said in hers that he had, like, she made it sound like he had done it a few times. So I don't know. That's the only one that's in the transcript from his deposition, but on this, but she had said in hers that done it a couple times. So here's the hole in the wall, and there's the ADT system, and here's the hole. Okay, so here's Renee. Okay, so these are the texts from Renee, his second wife, Eva's mom. She says, I'm deeply disappointed that you distorted the truth about who you really were when I married you. I loved you through finding out you weren't really what you pretended to be. You kicking me so hard on New Year's Eve on our honeymoon because you were having trouble functioning in certain areas. You holding a gun to your head twice in my home that I opened to you with my children that still love you. Having to sell everything down to my wedding ring. Finding out you were on Viagra, which all you had to do was tell me, you know I wouldn't care. Trying to film us making love on our honeymoon. Finding out that you wore eye pencil. On and on. I loved you so much. I can't see because of her fingers. Something to think you would take pictures of me without asking. Doug, I wouldn't do that to you. I love you. And then this is showing how ripped he was. This was all part of the the defense's argument that he was so so much bigger and stronger, and why she would be scared of him. You know, his first marriage only lasted 6 months, and I couldn't find a whole lot about that. It makes me wonder why. These are some of the texts. Remember, she said that he had talked about being in the CIA and stuff like that. So this is some of that stuff. Let's see. I call some special forces training, which often, sadly, is hardship. But no, she is concerned about me traveling so much. And one of my companies, she knows enough to be a little concerned. And then Ashley says, what does she know that I don't? And he said, what I told you about partner from CIA, we provide electronics used in undercover stuff. And she knows Mr. John is very much a trained for certain stuff, plus what we do at the ranch. So her sweet mind isn't quite sure how it all related to me, like always being armed. And Ashley said, are you doing things that are dangerous? And he said, I'm not. And it says, being armed is just being smart. And he said, yep, I left those days. And Ashley said, but I hope you don't put yourself in any unnecessary situations. And he said, from 1999 to 2005, I lived in very much concern. These are her scratches that she... Oh, an eye pencil is a camera. We learned about those. Demonstrative on the knuckles. Yeah, I thought it was eyeliner when they first said it. They told me when they brought it up, they're the ones that told me it was a camera. I didn't know that. No clue. These are pictures of the house. Firearms. That's the setup of the house. That's her and the neighbor's house. Oh, okay. So this is the people who were walking the dog. They said that they heard 6 shots and then all of a sudden saw a female come running out of the garage with a pistol in her hand, running to the house next door, banging on the door, screaming and yelling. So I think that this part's important because they said, let me scroll down to it. They're asking about this. It says, I don't know if she was saying help, but she was screaming so bad. It was like a mixture of a cry and a scream. Oops. And they said from the time they heard the shots until the time she came running out was only less than 30 seconds. And they were just saying, I was worried. I was thinking I didn't want this to get ugly. Let's see. Telling him to call 911. So you mentioned the fact that you guys normally live in the country and you're familiar with the kind of sound of gunshots and whatnot. They just recently moved into that neighborhood. I mean, really, the main thing about their stuff is that it was, like 30 seconds later. And that's it. That's all of the motion to dismiss. So, I mean, all of that is, you know, I think that's all of that stuff. Oh, I gotta go. Okay. Well, I have to get going because I have a birthday dinner that I have to attend. But, hold on, I gotta look it up. My arm muscle is like cramping. I keep grabbing it. I don't know. I haven't seen the. Oh, let me look at one other thing. I was looking up to see if I could find like eye pencil thing or whatever, but I don't see. I don't know. I didn't see it. Somebody said it's a camera. I've never heard of it. But, or eye pen or whatever it was called. I don't know. All right, I gotta get going. I guess we'll see what happens tonight. If there's a verdict tonight, then we won't be back tomorrow. If there's not, then we can come back tomorrow. We'll just have to see, play it by ear and see what happens. Maybe if I'm home, depending on how long they stay, if I'm home from birthday dinner in time, then, and they get a verdict, we'll go live. I appreciate everybody hanging out. Y'all are awesome. Thank you so much. Welcome to our new members that joined today. And, oh yeah, I can do that. Hold on. Is he staying live? Okay, I'm going to portal us over to RA, or portal y'all over to RA while I go to birthday dinner. If you have not hit the like button, please do so. It helps me. Wait, did it save it? Recovery addict. Save. Okay. There we go. All right, now it's going to take you over to RA. I appreciate all of you. I will see y'all. Oh, Broken Baker's redirecting to me. Sorry, Baker. Hey, hi. I love you. I'm sorry. I'm leaving. I have to go to a birthday dinner, so I'm actually leaving and having. It's like just a field trip all around these YouTube streets. So, I would stay if I could, but I have to be at a dinner in 30 minutes. So I will see y'all maybe later tonight, maybe tomorrow. We'll kind of play it by ear and see what happens. But I appreciate all of you. If you haven't hit like yet, please do. And I love you all so much. Y'all are the bright spot in my day. I appreciate you.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?